I might mention one more thing.
So we are live and recording now. Do you want me to stop? We should be live and recording once again. And let me just pull up the court cry. All right. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court. We are your panel this morning, and sitting with me this is on my right, Justice Neyman. I don't know where that is on the screen. On my left, Justice Lemire, and I am Gabrielle Wolohojian. Although we are conducting this argument by Zoom, the ordinary rules of our courtroom apply, and that includes that each side will have 15 minutes to argue with no rebuttal. And with that, I'm going to call the first case, which is Commonwealth versus Luis Martinez-Peguero, case number 2020-P0157.
Good morning, and may it please the court, Matt Spurlock for Mr. Luis Martinez-Peguero. The convictions below rest on two violations of Mr. Peguero's fundamental constitutional rights. Now first, Mr. Peguero was seized without reasonable suspicion when 5 officers surrounded him in a park with his back against the wall in a coercive show of official authority that did not intend to be denied. Second, the allowance of the peremptory strike of the sole prospective Hispanic juror violated the Equal Protection Clause of the 14th Amendment and Article 12 guarantee to the judgment of one's peers. Now, I'd like to begin discussing the seizure issue. This case really lies at the intersection of Mata and Rodriguez. The basic inquiry is whether officers projected a show of official authority that a reasonable person would consider coercive. That's from Mata. Before Mr. Peguero allegedly disposed of the contraband behind the wall, that's the piece from Rodriguez. So the critical question on these facts becomes one of timing. At what point did the officers who were in the process of encircling Mr. Peguero, at what point did they assert their official authority in a coercive manner that a reasonable, objective person would have considered that he was not free to leave and that this crossed the line into a coercive inquiry, which is a kind of inquiry that demands constitutional scrutiny precisely because it limits people's freedom of movement. Now, to recap the facts, Sergeant Blue orchestrated and planned that all 5 officers would surround Mr. Peguero and his companion sitting beside him on the wall.
Okay, so can we stop right there, Attorney Spurlock? At that point, had there been a seizure?
Well, no, Your Honor, not at the point where.
Right, I'm just trying to find out.
The seizure occurred when the officers actually surrounded him on all 4 sides.
But they didn't, I mean, I don't know. I didn't see anything in the record that said they surrounded him at the moment when he dropped the drugs behind the wall.
Well,
my reading of the record was that they were 100 feet away.
Your Honor, the record reflects that Sergeant Blue was 100 feet away. He was approaching from the north through the park, through the softball field, and he was in the outfield at that point. And he said that within seconds after observing that, he was able to actually physically reach him. So we have 2 facts about that. Within seconds, he reached him and 100 feet away. The other officers, 2 approaching from the east and to the west, may well have been closer. As I read the record, they all sort of were able to reach him physically at about the same time.
So assume they're all moving because I didn't see anything that put them closer than 100 feet. I mean, you would agree that there's nothing in the record that says that they were closer than 100 feet from.
There's nothing. I agree, Your Honor. The record, as I read it.
So assuming that they're all moving at the same rate of speed because there's nothing to indicate they weren't, wouldn't that lead us to think they're all 100 feet away?
I agree that's a reasonable inference. My only point is, is to correct maybe what might be thought from the judge's order, that they were all approaching from the same direction, right? They were approaching quite clearly from the facts from the east and the west and the north. And, that's significant for the seizure analysis. Not only is he vastly—
What did the officers do apart from approaching or being 100 feet from the defendant at the moment he decided to dispose of the drugs?
Well, okay, that's assuming they're all 100 feet. They're all then walking in towards him. So increasingly approaching, and that's it. That's essentially what they did. They surrounded him on all sides in a manner that any objective, reasonable person would instantly recognize as coercive.
Well,
Now,
is there anything in the record that indicates what he was aware of?
yes, there is, Your Honor. The police incident report, which was submitted as evidence at the motion for new trial hearing, and the trial testimony also submitted as evidence and considered by the judge as evidence. Both.
But there was no testimony or affidavit from him.
Nothing from him, no. Nothing.
So we don't know if he saw one officer, two officers, three officers, four officers, five officers, or no officers. We don't know what he saw at the time he lied down and dropped the drugs, theoretically.
Well, we know from the record that he at least saw two officers that were approaching from the east. That's because the police incident report submitted by Officer Trainer states that he observed them, that the defendant, Mr. Peguero, observed them, and in reaction to that observation, then disposed of the contraband. So, and that fact is echoed in the trial testimony.
So he was aware of two officers?
At least two officers. And of course,
that's all we can assume from the record.
That's all that's in the record. And of course, there's more facts that bear on this analysis that's in the record. I would like to say that, two officers is more than enough to constitute a seizure. I mean, five officers, of course, is even more coercive. But Sergeant Bellew, he desired that that his attention would be drawn to the uniform officers approaching from both sides. That was sort of the intent and effect. We know from the record that he did observe at least two officers, and two officers is enough. I mean, we have cases like Manu, where there's only two officers. We have Stout, DeBow, just many cases where you have a chase situation where there's one or two officers, and that's enough for a stop, for a constitutional seizure. And if it's true when the defendant is fleeing, it's certainly true when the defendant is stationary and the officers are the only ones moving in.
Mr. Spurlock, police conduct investigations all the time. They respond to calls for assistance all of the time. So, I mean, assume, for example, that the police get called to respond to some sort of disturbance outside of the T station in the Boston Common down near downtown crossing. And two officers get the call and they come walking from Park Street, and two other officers come walking in the other direction on Tremont Street, and they get to within 30 yards of the defendant, and the defendant notices them. Are you saying that merely by walking toward the defendant at that time and the defendant notices them, at that point the defendant is seized?
Not necessarily, Your Honor. This is a fact-bound inquiry. And one of the things that we know matters is whether the intent of the officers to actually seize the person and compel him to answer their questions is effectively communicated. And we know that this was actually Sergeant Bellew's intent. And we know that this was effectively communicated. We do have another fact here, which I think is helpful, where the companion, let's assume, the man seated next to my client, Mr. Peguero, does actually attempt to leave. And he is immediately turned back.
But
now,
the record doesn't show that happened before the drugs were dropped behind the wall.
You're right, Your Honor. It appears to have happened simultaneously. From what I can tell of the incident report and the trial testimony, they both happened at about the same time. Now, whether
I don't know how you can make that assumption.
That's fair. We don't know when they happened, but as I read the record, they both happened in reaction to those men noticing that they were being encircled and reacting to that. So my point is that it doesn't matter if Mr. Peguero noticed or not. That's not the inquiry. This is just, it's more evidence that the police, these officers actually intended to, of course, detain these men. I mean, they were in the process of detaining them.
How would we distinguish this case from a situation where people engaged in some kind of unlawful activity observe police officers nearby and say, you know what, it might be prudent for me to hide the contraband in case the police come over here.
Mhm.
And that, I think we could all agree, is not a seizure, it's just a decision they make in their own interest, not based on necessarily, you know, it's not going to be any unconstitutional event. How do we distinguish this case from that?
Certainly, I agree that that would not be unconstitutional. I would point the court to Rodriguez, which is the sort of seminal case on this topic that teaches that when the contraband is disposed after seizure happened. So in that case, 2 officers walked up to the defendant in that case, and then after they had approached her, she dropped, you know, a package on the ground. So that's a situation where she well may have been seized, the court held, because actually what the police were intending to do, whether they had reasonable suspicion or not, is a separate question. You know, Commonwealth never argues that they did here, and in fact, there's nothing to support reasonable suspicion. But the fact that the officers had at that point exerted their official authority makes the difference. In the situation hypothetical that Your Honor just described, the police had not exerted their official authority to seize those people. Those people had noticed the officers, presumably with no intent and effect of effectuating a seizure, and, you know, reacted in their own interest, as you put it. That's not the situation where we have here. Here we have.
But this is what's confusing to me. We don't take the officer's intent into account, do we?
No, well, it is taken into account only to the extent that it is communicated to the defendant.
Right.
And in this case, it was.
Where in the record are you saying just by walking up, the fact that there were 5 people walking up, 1 under plain clothes, 2, we don't know which ones, how many the defendant noticed, and they were 100 feet away?
Yes, when they're surrounding him on all sides, moving in, and when his back is against the wall.
So there's nothing in the record that uses the word surrounded?
No, but I think that's a fair description of when you have people on the north, south, east, and west, and a wall behind you, looking at, you know, all the circumstances as Mata teaches. Now, I would like to reach my other jury issue, if that's all right. I noticed that my time is ticking, unless there's any other questions on the seizure. Okay. Okay. Thank you.
On your other issue, it would be helpful for me if you explain whether or not the issues you raise on appeal were preserved at trial. Specifically, I don't see any objection at trial to pretext or allegation of pretext. I don't see any claim by defense counsel that this was a race-based challenge.
Your Honor, that's not how I read the record. Defense counsel.
I'm looking at page 21 of the transcript specifically. I believe it's, I'm not sure of the volume, but defense counsel says, after the Commonwealth used their peremptory challenge, the only juror of color, the only Hispanic trial member of the Lynnae was removed. I just want to make note of it. I will answer that we're not content at the end of using my peremptory challenges just because of the situation. I just want to note it for the record. There's no claim there that the prosecutor was making a race-based challenge. Instead, the claim was, I lost the only juror of color, purportedly, in the Lynnae, and therefore, no matter what, I'm just not going to be content. That strikes me as materially different than saying the prosecutor took race into account in exercising that peremptory challenge.
I disagree, Your Honor. I think all the parties knew exactly what was going on in that case, including the judge, and treated this as a Batson-Soros challenge. That's why the prosecutor, you know, attempted to justify the challenge, saying that it's not race-based, and that's why the judge, you know, in my view, went beyond step 1, accepted that, and actually made an argument, and he made a ruling on step 3 that purported to accept the reasons, the justification given here, the juror 11's brother's criminal history in another state. So, this is clearly just by the books, bats and swords. That's what happened. I don't think the court was not on notice that that was the basis of the challenge as may be appropriate for waiver. So that's my view of the record. Our notes that the Commonwealth makes no waiver argument in the sense that you're describing it there.
I don't think it's waiver. I think it affects our standard of review, but go ahead.
Well, all I would say is that there is a clear ruling, although insufficient by the judge. I mean, he doesn't make, he rules on adequacy and genuineness, but does not make any specific findings. And that's a situation that the precedents teach that this court should review actually de novo, because, he just parrots the standard. And, I would just say that here it was not adequate or genuine. It was not genuine because the judge did not consider the comparative discrepancies between juror number 12, the white juror that had his own criminal history, and juror number 11, whose brother was criminally involved. And also, of course, a disparate impact, which the court can take into account and should take into account on that's in step 3.
Are you making the argument that the reason provided by the prosecutor here is, you claim it's pretextual?
Yes, Your Honor.
Are you saying that that reason in and of itself is pretextual as a matter of law because of the statistical reasons that ostensibly flow from it?
Not necessarily, Your Honor, but in this context, it certainly was, when you have this other juror who was not looked at in this manner, and then the failure to consider the disparities. And of course, I have my Article 12 argument, but I suppose I have to rest on my brief for that because it seems my time has expired.
Well, I do have another question. I understood from your brief that you are arguing for a bright line rule that people falling within a protected class can't be peremptorily struck just because they have a family member who's been convicted of a crime. Is that correct?
Under Article 12, Your Honor, yes, I think that's correct. There's a presumption that that reason would be invalid. And that's similar to the rule adopted in Washington State, more recently in California. So because of the overlap between discrimination, the effect, in other words, of justifying your challenge based on that, that there should be a presumption that that is just not going to be adequate or genuine, to put it in terms of the test we have now. Of course, that presumption can be, possibly overturned. We have, for example, the case of Hernandez, where, yeah, there were Spanish-speaking Hispanic people, but there was non-pretextual reason for that, right? The non-pretextual reason was, well, they understood Spanish so they can circumvent the translation process. If there was another reason, like, yeah, there's a connection here, this person has been prosecuted by the same office, these sorts of reasons that could overcome that presumption that reason was improper, that the criminal history of a family member was improper. This is all under Article 12, on my view.
All right, I think we have your argument, and I don't see any other questions. Thank you very much.
Thank you very much.
We'll hear from the Commonwealth. Attorney Leary.
Good morning, may it please the court, Catherine Leary for the Commonwealth. I'm going to start first with the motion to suppress issue. And I want to reiterate or start with that this was framed as an ineffective assistance of counsel claim, meaning looking at the police report, would a reasonable defense attorney have thought it was necessary to file a motion to suppress in this case? And looking just at that first prong of whether it was reasonable or not, the police report, I think it's the way I read it, and I think it's clear, is these police officers were just walking up. There was no show of authority. There's really no evidence in the police report how close they were or that they were surrounding the defendant in close proximity beyond walking up on a mere patrol before the defendant dropped the drugs. So based on that, and then it's not unreasonable to think that the defendant had abandoned. Police officers walking up to somebody, even in pairs, there's no evidence that they're running aggressively, talking to the defendant, telling him to stop or stay. It's just not it would constitute, everything would turn into a seizure if just the mere presence of police caused somebody to do something, drop their drugs.
Is there a motion for new trial filed in this
There
case?
was, Your Honor, and just solely on this issue, not on the peremptory issue. So there was no extra evidence added to the record on that, but onto this issue, a motion for new trial was filed. The police report was submitted. The trial judge did consider, the motion judge did consider the trial testimony, although, and I think that's more to the prejudice prong, would the motion have been successful? However, I would point out trial testimony is obviously different than what would come out in a motion to suppress. It's an imperfect way to measure if the motion would have been successful. But even under the trial testimony that the motion judge considered, I read the record between the police report and the trial testimony that the police officers were not immediately surrounding the defendant when he dropped the drugs, that they were just walking up. So even then, there's no prejudice, that there's nothing to suggest the motion would have been successful.
And am I correct that there was no affidavit from the defendant submitted in connection with the motion for new trial?
I don't believe so, Your Honor. I believe it was just an affidavit from the appellate attorney.
That's what I saw.
If there's no further questions on the motion to suppress, I would just turn to the peremptory challenge issue. Here, Judge Gaffney is an experienced district court judge, and he's in the best position to determine whether or not there is a pattern, or under the clarified standard under Sanchez, whether there was an inference of a discriminatory purpose in exercising the peremptory challenge. As Justice Neyman pointed out, I think it's clear, even from defense attorney's own assertion at trial, that he's just noting that in his view that this is the sole Hispanic juror who's been struck. I would suggest that there's not a lot of record support for that, but even if you presume or assume that that's true because the Commonwealth and judge didn't contradict that, here it's clear when the prosecutor exercised this peremptory challenge, before it was even objected to, he said, I'm using it because of the fact that this close family member to this juror has been incarcerated. And then he consistently stated that was the reason. The fact that the prosecutor stated that after there was an objection is just by virtue of the fact that prosecutors always want to put on the records why they're doing what they're doing for this very reason. And I think Judge Gaffney was in the best position to look at the demeanor of the prosecutor, the fact that the prosecutor had offered this non-discriminatory reason before there was even a challenge to his peremptory challenge. That there wasn't even implicitly found there was no even prima facie case made, and that this was properly exercised for what has been recognized as a very valid reason. If the court has no further questions, I'm happy to rest on my brief.
I don't see any. Thank you both for your arguments. An interesting case, and your arguments were well made, so we appreciate it.
Thank you, Your Honors.
Thank you. Case is submitted. Welcome to this sitting of the Appeals Court. Our next case is Commonwealth versus Christopher Costas, case number 2019 P0583. We're ready whenever you are, Attorney DeBernardis, if I pronounced that correctly. I'm so sorry.
You did. Good morning, may it please the court. My name is Christine DeBernardis, and I represent Christopher Costas. A major issue in this case surrounded the complaining witness's assertion of her Fifth Amendment privilege against self-incrimination. As the court knows, there were 4 arguments in the defendant's brief dedicated to this issue. And so I'd start with that particular issue. In starting with that issue, I'd ask the court to keep in mind what the defense was in this case, and it was twofold. Primarily, the defense here was that this was a relationship that was characterized. You can call it whatever you want to call it. You can name it however you want to name it. But it was a relationship characterized by secrecy. These folks had a relationship that they kept outside of their families and outside of their workplace. And that the instances that the Commonwealth is using to say that the instances that they say constitute criminal harassment in this case are characteristic of this very relationship. And where Mr. Costas believed this relationship to be ongoing, his actions did not constitute criminal harassment. That's the first part of the defense. The second part of the defense is that where the complaining witness has changed her testimony, and I've briefed how that, I'm sure the court's aware, the various different ways where she changed her testimony, that she's mischaracterizing this relationship, and she's no longer credible, and her story is not believable. And when you take those 2 points, that forms the defense in this case. And it's very important to keep those 2 points in mind because they're very important as you analyze this case. The first argument in the defendant's brief is that the assertion was improper. And I think that even the Commonwealth agrees in the particular case that it's really just that first particular assertion that could lead this witness to have some sort of criminal liability. When you look at the other 9 and you see what the assertion relates to, these particular issues can't lead her into having any sort of a criminal charge. And so those assertions were improper. The defense should have been permitted that wide latitude of cross-examination, and the answers to those questions should have come into evidence. And I think it's important because without the...
Your choice of words there is interesting. You say defense should have been permitted that line of cross-examination. Defense counsel didn't object and wasn't seeking that additional cross-examination. Am I correct?
Well, I think, I think that lends itself to all of the conversation that was had at sidebar and during the various conversations, that the defense was allowed to ask whatever questions the defendant wanted, and that the witness could seek her assertion question by question. She could assert whenever she wanted to. So I think there's a...
That's the proper, at least procedurally, that's the proper approach, that the Fifth Amendment is actuated, or rather asserted, on a question by question basis, correct?
That is, yes, that should be the approach. It wasn't necessarily here.
So in the absence of objections, are you saying it's the role of the trial judge in the middle of a cross-examination to sua sponte interrupt the flow of cross-examination and say, no, that I find that is not a correct assertion of the Fifth Amendment each and every time?
I do think that I think it's incumbent on the court to certainly analyze it question by question. I think here there's the idea of the blanket assertion. And I think the problem is that this witness was given the blanket assertion that she's certainly not supposed to have. I do think there's a point to be made that the defendant did not.
I'm not sure I understand what you mean by the term blanket assertion. The witness asserted it in response to specific questions. The witness did not wholesale rest on an assertion of Fifth Amendment privilege to testimony at all. So I'm not sure what you mean by blanket assertion.
I think at some point it becomes almost a blanket assertion, though. Once Attorney Tran is appointed to her and she begins to be crossed again, there were certain questions she answered, but not very many. I think it becomes that she starts to assert question after question after question.
Well,
and so maybe
I don't know that the problem really is the quantity. I don't see that. But the problem appears to be that it was incorrectly asserted, that essentially the witness relied on the Fifth Amendment whenever she felt she was being impeached. And that's not what the Fifth Amendment is designed to do. So that seems to me where the crux of your argument is, as opposed to relying on the idea that it was a blanket assertion.
That's true. That's true. I mean, I don't think that the privilege was used the way it's intended to be used.
Right. And so then doesn't the question become that given that she asserted it in the wrong places, but there's no specific objection each time she does it. So the judge, unless you didn't point us to a case that says that the judge has the sua sponte responsibility to do something in the absence of an objection. So then we're reviewing for a substantial risk of miscarriage of justice, I take it, from the improper assertion of the privilege. And perhaps you could help us with that.
Well, I agree. And I think that's the way it's certainly been briefed in the brief. I think that the substantial risk of miscarriage of justice is that the defendant doesn't get this very important information to his defense. Because remember, I characterize his defense, and I think you can see in the transcript that the defense is that twofold portion. And now the defense cannot have those particular facts that support his defense.
But why can't the defense of credibility, right, that she's not credible, how is that undermined when, and I realize this feeds into your argument about the lack of an instruction about what fifth is, but how does that really prejudice the defendant, since her, our normal assumption is that when a witness asserts the Fifth Amendment privilege, the jury will make a negative inference from that, take a negative inference from that. So why is it that normal understanding that we have here doesn't mitigate your argument about prejudice when the prejudice turns on credibility?
Well, I think that does bring me right to that curative instruction argument, because the jury wasn't given any information about that. What the jury heard was, I plead my fifth, I take my fifth. And I think part of the problem here is that we haven't given the jury the information that they need to know that this is her Fifth Amendment privilege against self-incrimination. Not even those words were used. And I think that's part of the problem. I realize that my argument was more about the curative instruction being promised and then not being given. But the fact that there was no language whatsoever, we rely on the jury to use their common sense, certainly, but there was no education given to the jury that's even what we were talking about. So I think that becomes part of the problem, that there's no curative instruction to let them know what it is. So I don't think there's necessarily a idea that they did construe it against her or did think she was lying, because they may not have known what she was even talking about when she said, I take my fifth.
So you're not suggesting the curative instruction should have included that they couldn't draw an inference either way?
No, I'm not. No, I think the curative instruction needs to tell the jury something. The instructions are used to tell the jury how to treat information. And I think they're also designed to tell the jury what the information is. And none of that was given.
You would agree that the proper instruction, if it was to inform them of what the Fifth Amendment privilege meant, would also include that they should not make any inference from positive or negative toward the witness.
That's true. Yes, I think that they're
So you're selectively saying they should have just been instructed on what it was and not what inferences they could make.
I'm sorry?
You would not have expected the judge to instruct on any inferences they could make.
It doesn't sound like the judge was willing to instruct on inferences. So I think that the jury needs to know what the Fifth Amendment is, what it stands for, and then the jury will make whatever inferences and conclusions they want to from there. And I think that that's why the curative instruction is important here.
Going back to your first issue, the Commonwealth cites a case, Commonwealth versus Turner, 393 Mass.
Yes.
685. And Turner stands for the proposition that it's sort of well understood that a defendant may derive a benefit from a witness asserting a Fifth Amendment privilege in front of a jury and not answering the question. The cases, not just Turner, but cases that subsequently cite Turner, have said that it can make a witness seem evasive. It can impact that witness's credibility. So how does this case not square with Turner? It seems to me, in other words, that defense counsel may have made a strategic decision at trial to have the witness not answer the questions in front of the jury and derive that benefit that Turner contemplates.
I think in this case, I don't think that's the case here, though. I think by the read of the transcript, you can see that defense counsel wanted the witness to answer these questions. He pushed for her to answer them, and then he asked the judge to give that curative instruction. I think Turner also stands for other issues that are related to this case, though. When you look at the Turner case, it also leads to the issue regarding the cumulative and collateral argument that is in the third argument of the defendant's brief. And I think that in particular, that's where Turner is helpful to the defendant's case here. The court's aware of what the case stands for, but there it says that the assertion was okay because here it is collateral. It was used for impeachment only, and that it was also cumulative because you had that officer that testified to all the information that these witnesses would have given. And I think that's the point from Turner that I would emphasize to the court to take into account here, because that's different from this particular case. The argument number three, whether is that, as the court knows, that due to the selective assertion, the testimony of the witness should should have been stricken. And that's where Funches comes in, and many pages of the transcript are dedicated to this particular issue. I'd like to touch on.
You may have addressed this with Judge Wolohojian's question, but are you suggesting the judge should have sua sponte either conducted a individual Martin hearing on each question and struck the testimony without any objection, or in other words, you're suggesting that the testimony should have been stricken in general because of a refusal to answer all the questions.
Yes.
There was no objection to the questions. You're suggesting the judge should have made an analysis. You're saying sua sponte, he should have made an analysis. Is that correct?
I think that analysis should have been made as to each question. I think that's
but without an objection, you're saying that the burden is on the court to make that analysis.
I don't think the burden's necessarily on the court. I think where this was a case where there was so much confusion as to how this should be done. Think about how many pages in the transcripts are devoted to people not understanding how this is going to happen.
But what should have happened? In other words, you're suggesting the judge make an analysis. I'm not sure. Absent an objection, when would he have made the analysis, and in what form would the analysis have taken place? Separate Martin hearings on each question?
I think there just needs to be no, I don't think there needs to be a separate Martin hearing on each question. I think there just needs to be an analysis of each question as to whether or not there really was a Fifth Amendment privilege there. And I realize that
you don't think an objection was required?
I think because there wasn't an objection, that's why the evaluation is analyzed for substantial risk of miscarriage of justice. I think that's why you have to analyze it that way. If there was an objection, we'd be looking at it from a different angle, but where there wasn't, I think that's where substantial risk comes in.
Okay.
Because my time is running out, I just want to touch really quickly, if it's okay with the court, on argument number 6, which is the refusal to amend the verdict slip. This is, and I'm going to touch very quickly because I only have a couple of moments, but this is where the defense attorney asked for the judge to put a special question on the questionnaire and to for the jury to indicate which 3 instances of harassment the jury agreed constituted the 3 instances in element number 1. And I think that this is very important because this indicates, if the jury is able to say, we think these 3 particular instances of harassment constitute and make up element number 1, we know then that the jury's verdict is unanimous. Here, that did not happen. We know that he was found guilty, that the jurors said element number 1 was met, but we don't know with certainty that there were 3 instances. If you look at the Conifrey case, I know that the Commonwealth claimed in their brief that they didn't have separate theories flowing between their case so that the jury needed to select a particular theory. But if you look at Conifrey, that case was a case of indecent assault and battery. There were 8 different instances that could have constituted an incident of indecent assault and battery. And the court found that because any one of those 8 could have met the burden on the charge, the jury needed to indicate which particular instance they wanted. Here we have a case, the Commonwealth didn't say, I'm talking about instance 1, 2, and 3. There was basically a bunch of different instances thrown out that the jury could have picked from. There weren't any that were particularly numbered or identified in any way. And then the jury was left to determine which of those constituted harassment. I think it's very important that the jury should have laid out those so that we know their jury verdict is unanimous, because without that, we can't guarantee that Mr. Costas received a fair trial. And I think if the court has no further questions, I know my time is down to just a second. I would thank you for your time and rest on the remainder of the issues in the brief.
Thank you very much. I don't see any questions. We'll hear from Attorney Ferreter now. Thanks.
Thank you. Good morning. If it may please the court, Timothy Ferreter, Assistant District Attorney from Middlesex, representing the Commonwealth. And I'll pick up where the defense attorney left off with the Conifrey case. And I think the important distinction in that case is the 8 different incidents the victim testified to in that case could each constitute 1 count of indecent assault and battery. And those were separate and distinct diverse dates in 1 indictment. Here, I think what's confusing about criminal harassment and stalking is because the element is a series of acts that require at least 3 incidents, it gives the appearance sometimes of being a diverse date indictment, but it's not. It's really 1 continuous course of conduct. And under Santos, a unanimity instruction, or in this case, what was requested, a special verdict slip, isn't required because we're not alleging different theories or that the crime occurred distinctly on different dates. We're saying that the crime occurred between June and November, and because of the elements of this case, the unique elements of criminal harassment, it's one theory, and we don't need the unanimity about when each date occurred, but that they find that 3 incidents did occur, and that's why a unanimity instruction is not required or a special verdict slip in this case.
Would it have been an error to have a verdict slip that asked for the 3 acts to be identified?
I don't think it would be necessarily an error. I think the SJC and the First Circuit, in the cases I point to, have warned courts away from it, but it is left under the rule to the discretion of the judge. But it's just not required in this case, either a special verdict slip or a unanimity instruction, where there isn't separate theories. It is one continuous course of conduct that was alleged in this case. Similar to Santos, they didn't have to pick out which act of force caused the victim to hand over her money, because there's one discrete act. Here, it's over time because that's the nature of the crime, but it's one continuous course of conduct, which is different than Conifrey, which was 8 distinct acts in one indictment in a diverse states indictment.
Do we have any cases where a specific unanimity instruction has been given on a harassment charge?
I don't have any off the top of my head. Julian is a stalking case, which of course has a similar 3 instance. It wasn't requested in that case, and this court said that it wasn't a substantial risk of a miscarriage of justice to not give a specific unanimity instruction where there was sufficient evidence of stalking. And I think that's the most similar one I have in my brief.
There confusion or debate at trial as to what the 3, or I think you argue 4 instances of harassment were? I
mean, there wasn't debate in terms that they occurred. They were all backed up by email and 911 calls. I don't think the defendant disagreed that the incidents occurred. It was, the dispute was whether that the course of conduct rose to the level of stalking or whether the defendant acted with the intent.
So sometimes you will see a trial judge in their instructions basically reach out to the parties and say, look, we're talking about the instances on October 1st, October 2nd, and October 18th, and I'm going to instruct the jury as such and just say those are the ones you should focus on. Why would that not have been proper to do here? Or are you saying that would be proper, but it's not an abuse of discretion to refuse to do so?
Well, in this case, that instruction that you're talking about wasn't requested, so I don't believe it's a substantial risk to not give that type of instruction, and I don't think that's what's been briefed here. And that
No,
but
sorry.
No, go ahead, please.
But isn't the request that was made with respect to the verdict slip sort of de facto the same kind of thing?
Yes, Your Honor, but I think for the same reason that a specific unanimity instruction isn't required, this special verdict slip, because they kind of go hand in hand, wasn't required. Because it's not we're not saying criminal harassment occurred on this date and then it stopped, and then it occurred again on this date and then it stopped, and then it occurred again on this date. It's one continuous course of conduct. And under Santos, a special unanimity instruction isn't required when we're really advancing one theory of the case. And I think just because of the nature of the element, it's confusing, because harassment requiring the 3 incidents makes it look like a diverse states incitement when it's really one continuous course of conduct that just takes place because of the element over time.
Mr. Farida, can I ask you a question on the curative instruction issue?
Sure.
Specifically, are there any cases, published cases from our court of the SJC that state that when a witness asserts a Fifth Amendment privilege, number one, that a judge either may or should give an instruction about how to consider that such testimony, number one. And the second part of the question is, if so, what guidance have we given in terms of what that instruction should say?
I haven't found a lot of case law about giving, first of all, taking the fifth in front of the jury. There's not a lot of cases, or what the judge should do specifically. I know the general guidance to the judge seems mostly to not let it happen in front of a jury. That did happen in this case. So I haven't seen a specific instruction. I think in criminal cases, it's been pretty clear that it's not something that should be commented on by the counsel. So I think an appropriate instruction, if one to be was given, was that you can't make an inference on either side. This is different than the civil rules of evidence that does allow an inference to be made. So I think if there was an appropriate instruction, it would be that you can't make an inference on either side, which I think benefited the defendant, because under cases like Gagnon, the court said it's been long recognized that jurors tend to view a witness's invocation of the privilege as a clear confession of a crime, which I think in this case could only have benefited the defendant. And I think going into the Fifth Amendment argument, I know there's a number of nuanced arguments, but if I can just make a general comment about the cross-examination.
Just before you do.
Sure.
Just so I'm correct, the answer to the first part of my question is you're not aware of any cases that explain that a judge can or should provide an instruction to the jury as to a witness's assertion of the Fifth Amendment privilege and what that means.
Correct, Your Honor. And going to the Fifth Amendment privilege claims, and just in a general overview of the cross-examination, I know there's several nuanced arguments, but if the court looks at the cross-examination as a whole, I don't believe there's any prejudice to the defendant, because not only he was able to ask and get answers to all the questions and the topics that are listed in the defendant's briefs, the prior and consistent statement about the relationship. This is all in the May 11th transcript. You look at page 159, she admitted that she lied under oath when she said, yeah, I guess that wasn't true. 153, she was asked about her relationship and what she said in the past, and she said she described it as pretty good work friends in front of the court. Whether any touching was welcome or consensual, you can see that on page 89 and 91, 207, that she said it was consensual all the time. Was the victim threatened by the defendant's emails, page 117, 121. You'll see that all these topics have been well covered, and the Fifth Amendment was really sporadically interspersed throughout. So I don't think, so not only did the defendant get all the answers to his questions, he got the evidence in, and then he also got the victim to assert her fifth sporadically, and I think that jurors naturally draw a negative inference. So I don't think you can imagine a much better cross-examination other than the victim just saying, all this was a lie and I made it all up. Her credibility was thoroughly attacked, both by her answering the questions and then sporadically asserting the fifth at seemingly random occasions. So I think if you look at the whole cross-examination, I don't believe the defendant was prejudiced, despite I think the errors in the Fifth Amendment being asserted when there wasn't an actual claim.
And your view on the prejudice comes from the fact that we would assume that the jury drew a negative inference about credibility from the witness's assertion of the fifth.
Yeah,
is that primarily why there would be no prejudice, or is it that the defendant was able to elicit the impeachment evidence nonetheless?
It's both, Your Honor. That he did get all she did answer, I want to say, I don't know what the percentage is, 90%, 95% of his questions, including on all the topics that she also invoked the fifth on. So he was able to get all the answers, including the negative answers that she previously lied under oath. That's page 153. On page 140, her prior statement that I actually didn't feel threatened by the emails, but I felt threatened when he was following me. So he did get all the answers and then sporadically interspersed the fifth, which I think this court and the SJC and Gagnon and Turner have said jurors draw a negative inference on. It's something that's well known enough in popular culture and the news that I don't think we have to leave our common sense at the door. And I think jurors don't either. And I think they know enough about the Fifth Amendment to know that it's a negative when they're taking it.
Did any party seek or did the judge conduct a voir dire of the witness?
There was a Martin hearing. It's in the transcript before the court. And in terms of whether it should have been struck, I think under Funchess, what the court looks at is whether it's collateral and cumulative. And my argument about it being cumulative is it's really cumulative of the victim's own testimony. Everything that she took the fifth on, she also answered, which is, I know it's different than Turner, where the cumulative was of other evidence from another witness. But in terms of whether she lied under oath, she admitted to it right on page 153. So asking about it again is just cumulative of her previous testimony, where she admitted that when the court asked her in the HPO hearing whether she had a relationship, she said no, and she agrees that that was a lie, right on page 153. So I think it's really all the time she took the fifth were cumulative of her very own testimony at other points, and even later points where she answered questions on the same topics. If there are any further questions, I know there are several other topics in the defendant's brief. I'd be happy to take them. Seeing no further questions, I'd rest on my brief.
Thank you. Thank you both. It's an interesting case. We were aided by your arguments and the case is submitted.
All right, we are live and recording.
Good morning, everyone. Welcome to this sitting of the Massachusetts Appeals Court. It's my great pleasure this morning to be sitting with Justices Neyman and Justice Lemire. My name is Gabrielle Wolohojian. We are going to be hearing this morning Commonwealth versus Michael Wilson, case number 2020 P0177. Although we are conducting this hearing in this argument in this format in light of the ongoing pandemic, all the ordinary rules of oral argument apply, which means that each side will get 15 minutes to argue and there is no rebuttal. And with that, we're ready to go. Attorney Rubin, we're prepared.
Good morning. Good morning. May it please the court. Eric Rubin for the defendant, Michael Wilson. This is, of course, an appeal from his conviction for possession of a Class B drug. Thank you also for arranging for us to be able to do this this way during the pandemic, so we don't have to run the risk of getting ill or making anyone else ill. So thank you. I believe that my sister and I are in rough agreement about the facts of this case. My client was a passenger in a motor vehicle, which is first spotted by law enforcement going past a line of cars, making a movement across that line of cars onto a ramp on, I believe it was 95 north. It might have been south. I apologize. It was 95 for certain. And as a result, police pulled over the vehicle. During the time that the vehicle was under the, while it was being seen by the police as they were pulling the car over, there was some movement between the two individuals in the vehicle. However, according to what I have here, of course, the defendant looked back, but he didn't move toward the console. He didn't move toward the dashboard or the driver's seat. And the moment that I believe it was Officer Kiley is the officer that made the stop, he asked for backup. And as a result of what he believed to be a situation where he needed a pat frisk to occur, he had both individuals removed from the vehicle. They were pat frisked. Only at that time did the drugs in question, the Suboxone, fell to the ground, and then the arrest of my client was made.
May I ask you a question about the facts, just for clarification?
Certainly.
As I understand it, your client was not given the exit order until after this, he was seen putting something into his waistband?
Yes, there is something, there is testimony about him putting his thumb in his waistband. And why it's a good moment as any to start my argument about why this isn't an inappropriate premise for a stop and frisk. We do not have to abandon our common sense. When we see someone put their thumb on a waistband, it could, a firearm or other weapon is distinguishable and easily seen. Someone putting their thumb in a waistband does not in and of itself trigger an ordinarily prudent person or ordinarily prudent law enforcement officer to immediately think that there is some type of danger.
But I didn't remember that the officer specifically said, I saw him put his thumb in the waistband. I thought it was that he saw him put something in his waistband.
I believe that it was Officer Beausoleil, who I believe is the second officer at the scene, saw the defendant hide something in his belt.
Right, hide something in his belt. That's right.
That is more accurate, right, Your Honor. It's not, I may have read testimony, or for whatever reason I had it as a thumb. So you're right, hiding something in his belt. Still, though, I believe we're in a situation where we don't need to abandon our common sense. And there's a lot of pretext being used by law enforcement to do certain things. And this, I'm not alleging inappropriate behavior specifically, but I think that there's often a time when law enforcement will use whatever premise they need to remove an individual from a vehicle. And this may be one of those times. Now, I know, by the way, that there was an argument of a motion to suppress and that argument failed. But as I stated in my brief, that doesn't mean that the defendant had to re-object during the trial. In fact, the case that I cite, Grady, if I'm not mistaken, and my apologies, yes, Grady, specifies specifically, sorry, that's terrible, specifically states that you don't need to object, that objection, by dint of raising that in the motion to suppress, is enough to secure the defendant's rights on appeal. So I just want to address that because my sister addresses that. Yes.
Let's assume the issue is preserved. As I understand your argument, I've read your brief carefully, it's at pages 8 and 9, you're challenging the exit order. I don't see that you challenge the pat frisk or any other activity. You may challenge the pat frisk as fruit of the poisonous tree because of the exit order. But am I correct that you only challenge the exit order of the defendant on appeal?
Yes, Your Honor, but the exit order is everything. Without the exit order, the suboxone doesn't fall to the ground and we don't have a case.
So then my second question is, if I may, that you just told us that in this case, there is no, you didn't use these words, but you're saying apart from the defendant looking back, there's no furtive movements. But the judge found, and I'm at Record Appendix page 9, that while in pursuit, Sergeant Kiley, quote, observed Wilson to look back at him and that he and Simpfer were both leaning forward and towards one another. This caused the sergeant's level of concern to elevate. And then the judge subsequently concluded in the next paragraph, or found rather, along the way, the two men in the car continued to lean towards one another. Wilson persisted in looking at the sergeant's vehicle. And then the judge goes on and says the men's furtive movements were consistent with concealment, made the sergeant uncomfortable, and prompted his calling for backup. So it does seem that the judge made factual findings of leaning forward, which distinguishes this case from Hooker, and also made movements that he characterized as furtive. Well, I don't see you arguing that those findings are clearly erroneous. So what do we do with that?
Well, Your Honor, then that is a mistake on my part. What I suggest that the court does is look specifically at the testimony at trial. And also, which I don't believe is particularly different from the testimony at the motion to suppress hearing. I think that rather than rely on the judge's finding, you should look at the testimony itself. And I apologize for not being specifically clear about what that testimony was, or being able to get right to the.
There's no need to apologize. It's a good brief, but you would agree that trial testimony may not always be helpful in analyzing a motion to suppress because that issue is not necessarily the focus of the trial attorneys or the prosecution's theory of the case or the defense theory of the case, right?
Well, it may not be the best, but it's certainly, all of this testimony is sworn testimony, and it's up to this court to determine what they want to do with that sworn testimony. That would be my response.
The suboxone fell out of the pants bottom before there was an actual frisk. Am I correct about that?
I actually don't remember that, Your Honor. And for my client's sake, I think that while it is of interest, it is not the most important fact because it's really all about the exit order. Without the exit order, you don't discover this. So I'm not arguing that. What my argument would be was there shouldn't have been a removal of my client from the vehicle. There was no need for it, and therefore any other fruit of the poisonous tree would not be admissible.
I know you're not arguing it, but just on that point, I happen to be looking at the transcript on page 46 of the motion hearing. Bousselet says, as the sergeant was conducting a search, I noticed something fell onto the ground. So it sounds as though it fell as the pat frisk was being done. But I don't mean, I know you, go ahead, go right ahead.
No, Your Honor, I'm fine with that. I apologize if I interrupted you. I don't think I don't see, I think it's a distinction without a difference here. Once he's out of the vehicle, all bets are off, and therefore he shouldn't have been removed from the vehicle. That is the argument that I would make. I would like to address the second part of my brief, just because I see from the clock that I'm 2/3 through my time. And that is, of course, I'm sure a very welcome argument by this court that I want you to say that the Supreme Judicial Court has made a mistake in their holding in Pero. And I'm confident you would agree with me, but just to make it clear, the statute shows that, I'm sorry, I just want to make sure I'm very clear. The 277-38 states that in a prosecution for manufacturing, dispensing, or distributing a substance, if a defendant's relying on a prescription, they have to prove it. But that statute does not include possession. Now, I don't know if I would characterize this as a statute in derogation of the common law. I don't know that there's common law about the possession of Suboxone, but I think we have to be specific when we're talking about what's a crime and what's not a crime and how we're going to address that and all of the evidence and other particulars around a crime. And since my client was simply charged and ultimately convicted of possession, which is not listed here, I think that there's a problem. And I know that in Pero, the defendant presumed innocent burden, I'm sorry, the SJC ignored the language which didn't apply to the defendant. And I think that that was a mistake. It's hard.
Well, there was a possession charge in Pero, as well as a, I think, distribution charge, but there was a possession charge in Pero.
Correct.
And the Commonwealth, you know, as you acknowledge, held in Pero that having a prescription is an affirmative defense, and the burden is first on the defendant to put forward some evidence on that.
Right.
And didn't distinguish between the possession charge and the other charges. And that's the part that you're saying we need to find that was erroneously decided.
That's correct. When this instruction came to the jury, they were basically told what to find. And they were told, despite the fact that during cross-examination, the Commonwealth elicited testimony from my client that he had a prescription.
But later, not at the relevant time.
Actually, the testimony specifically, he didn't, if I'm not mistaken, and obviously look at the testimony, he said he had one. He talked about a bridge prescription, and you could read the testimony. It's not specific enough, I believe, to say it was only since the incident occurred.
But the trial transcript, at page 103 of the trial transcript, your client is asked, did you have an official prescription you got from a pharmacy on May 11th? Answer, no. So why is that not enough? I understand that there may be other explanations, but why is that not enough to survive a required finding of not guilty under Lattimore?
Because I believe, Your Honor, that also in the testimony, he talked about a bridge prescription, and the judge went beyond talking about what the testimony was or how they could interpret it. He demanded that the jury find a certain way. He characterized the evidence for the jury without the jury being allowed to interpret the evidence. In essence, what the judge did was he shifted the burden on my client, and he also told the jury what they should find. And neither of those was appropriate. And unless there's any other questions, I will rest on my brief and thank the court.
I don't see any. Thank you very much for your argument. Attorney Piccarini.
Thank you. Good morning, Your Honors. May it please the court, Danielle Piccarini for the Commonwealth. The motion judge did not err in this case in denying the motion to suppress the exit order of the defendant, who was a passenger in a motor vehicle which should have been a routine motor vehicle stop based on a minor traffic violation, very quickly escalated into a police pursuit that lasted at least a couple of miles, where the defendant repeatedly looked back at the pursuing officer and the defendant and the driver repeatedly leaned towards and forwards in the car. In this particular matter, all of the facts that occurred before the stop justified the exit order. And just to clarify one of the factual issues, when Trooper Bousselet noticed the defendant in the passenger seat moving around with his waistband, he did not transfer that information to Sergeant Kiley. So that information was not known to Sergeant Kiley prior to the exit order of the defendant. The facts that support the exit order are the fact that the defendant was in the motor vehicle while the car was being pursued. The trooper had his lights on. The car stopped in an actual travel lane on Route 95 South. The trooper testified that the defendant was particularly focused on the trooper, looking in the side rearview mirror repeatedly at the trooper, and again, repeatedly leaning towards the driver and forward into the vehicle. And the case law is replete with evidence that, or support, that where a defendant is leaning forward in a car, potentially down underneath the seat, that justifies objectively the trooper's reasonable suspicion to give the exit order. In this particular case, the officer doesn't need to point to any specific facts that the occupants are armed and dangerous for the exit order. It's merely the fact that the safety of the officer or others are potentially at risk. And that's exactly what we had in this matter.
Does the exit order automatically justify the pat frisk?
I would suggest that it doesn't automatically justify it because there is a different standard under Torres-Pagan, but in understanding that the defendant waived this issue by not raising it, if it were raised, I would suggest that the record does support a pat frisk. Again, looking at the totality of the circumstances, this was a lengthy police chase with repeated furtive movements by the defendant. And when the driver was pat frisked and no weapon was found, the Commonwealth suggests that that then raises the potential that the defendant had a motor vehicle. And I would rely on the decision from the SJC even just a couple of days ago in, if I'm pronouncing it correctly, Silvelo, where in a comparable scenario of a motor vehicle search, the Supreme Judicial Court held that where a defendant is getting out of a vehicle, the officer can reasonably fear for his or her safety because any other occupant may access a weapon left behind. So in this matter, where the driver gets out, no weapon is found, Trooper Kiley has a reasonable fear for his safety or others because the defendant is still in the vehicle and the defendant had those repeated furtive movements while being pursued by the officer with his lights on.
What's the standard for the pat frisk?
It's armed and dangerous under Torres-Pagan. And again, the issue was waived, but the facts support, the record supports that there was suspicion that the defendant was armed and dangerous in the vehicle. Moving to the jury instruction, if there are no other questions on that issue.
I thought under Torres-Pagan, it also required reasonable suspicion of a crime.
My reading was that it was armed and dangerous, and the court noted,
Only?
I believe so. Even if it is both issues, I would suggest that, again, the repeated movements of the defendant in the car would give reasonable suspicion to believe that he was hiding something, whether it be drugs or a weapon. So I would suggest under either standard or both standards that there would be enough evidence. Again, should the issue have been raised, counsel indicated that issue is not raised because it's only the exit order being raised at this time. As to the jury instructions, There was no substantial risk of a miscarriage of justice here, where the court specifically instructed that there was no evidence before the jury that the defendant had the legal authority to possess the Suboxone. The reason that jury instruction was proper was because the defendant himself repeatedly testified that he did not have a prescription on the day that he was arrested.
I'm sorry, what is a bridge prescription?
Respectfully, Your Honor, there was no testimony that there was a bridge prescription. There was a testimony that there was a bridge, not a bridge prescription.
Could it be inferred that a bridge was a reference to some sort of prescription or some sort of authority during some form of a waiting period to use a drug? I mean, why is that not a reasonable inference to be drawn?
It could potentially be, Your Honor. However, that was not, none of that information was brought out before the jury. All they really heard was that they'll give you a bridge, which is what the defendant testified. He didn't say who, quote, they is. He didn't testify about working with any kind of clinic or any kind of doctor. He didn't testify about who gave him this, quote, bridge. There was nothing on the record for the jury to find that there was a valid legal prescription.
And they don't, I mean, I think the language of the statute is not necessarily prescription, right? It's authority or something like that, authorized use or some, it's not, doesn't see, I don't believe it said specifically prescription.
Regardless, and
Model jury instruction, I believe, does use prescription, but we will look at both, of course, but go ahead.
The issue, Your Honors, is that the defendant, again, specifically testified that he did not have a prescription until about a week after he was arrested. There was no documentation presented to the jury about this, quote, bridge. Again, no information about who provided the bridge, what a bridge is. We're leaving that language to the jury to interpret in any way that they wish. And the trial judge correctly found that not enough information was presented in this affirmative defense where the defendant bears the burden of raising it to go to the jury as a potential defense. And if we were to, even if, which it would be, I would suggest inappropriate, even if Pero were overturned by this panel, and even if we were to say that Chapter 277, Section 38 did not apply to the defendant because he's only charged with possession, ultimately, this is still an affirmative defense that the Commonwealth does not bear the burden of challenging or proving otherwise until the defendant raises it.
But are you relying on Pero for that?
I would suggest that under Chapter 278, Section 7 in Commonwealth versus Cabral, which are both cited in the Commonwealth's brief, the defendant bears the burden of production when pursuing an affirmative defense. There was nothing listed on the pretrial conference report about this affirmative defense. And notably, the pretrial conference report was completed the same day of the motion to suppress, after the motion to suppress hearing was completed.
No, but you would agree, would you not, that the statute does not create or specify that this is an affirmative defense to the crime of possession?
I would agree, yes, that the statute does not use that.
So what authority makes this an affirmative defense where the crime is only possession?
I would suggest under Commonwealth versus Cabral, which cites to the Model Penal Code, and Chapter 278, Section 7.
Was that a controlled substance possession case?
Cabral was it was not. It was an issue about a bail bondsman. It's entirely different than the scenario before the court.
So again, I go back to, what is it? Is there any authority that specifically says in the case of possession of a controlled substance that the prescription is an affirmative defense?
I don't believe there's any specific statute about possession, no.
Or authority, I'm asking a case law, except for maybe Pero, right?
Right. I would suggest that Pero is on point. Notably, Chapter 277, Section 38 has not been amended since Pero, which was decided in 1988. Certainly, the legislature would have been aware if this was an issue that they could have addressed it and added possession. Ultimately, even if this jury instruction should not have been given, the defendant's testimony still supported the fact that he did not have a valid excuse or valid authority to have the Suboxone on the day that he was arrested. So it would not have changed the outcome if the instruction had not been given.
Am I correct that, I know there was conversation at sidebar prior to the defendant testifying, but am I correct that there was no notice provided to the Commonwealth of this affirmative defense?
It was not in the pretrial conference report, Your Honor.
Am I also, I'm sorry, am I also correct though that defense counsel on direct examination of his client did not raise the prescription issue, but that was actually started on cross-examination by the Commonwealth?
I believe the question asked by the Commonwealth, Your Honor, was where did the Suboxone come from? And I would suggest that that could be interpreted in different ways. It's not a question that I would suggest opened the door to the defense.
Do you believe that Rule 14 is an independent reason for the defendant to bring forward the issue of prescription?
I would suggest
independent of any case decision in Pero or Cabral.
I would suggest absolutely. It's comparable to a license to carry a firearm. There's no way for the Commonwealth to challenge the license or authority until the defendant raises the issue. The Commonwealth can't go out looking for every pharmacy or every clinic to determine whether or not the defendant had the authority or a prescription for Suboxone. If there are no further questions, the Commonwealth will rest on its brief.
Well said.
I don't see any. Thank you both. It's an interesting case. We were aided by your able argument, and the case is submitted.
All right, we are live and recording.
Good morning. Welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format in light of the ongoing pandemic. Although we are conducting the court in this way, all the ordinary rules of argument in the appeals court apply, which include that each side's argument is limited to 15 minutes and there is no rebuttal. With that, I'm going to call the case of Kelly Andrea versus Ralph Andrea, case number 2019 P1526. And we're ready whenever you are, Attorney Driscoll.
Good morning, and may it please the court. The lower court decided summary judgment at the time of the temporary order. It's clear from the transcript of summary judgment that the decision had already been made. And the judge actually said, well, this gives you the opportunity to appeal the decision of the temporary order. But the temporary order is based on an error of law. The judge found that the lack of language stating that a writer was required was fatal, but it was not. Under settled law, settled contract law, the fact that there is an incorporation by reference means that the statutes that were referenced as similar reasons for continuation were to be included in the contract. To state the language of the statutes, the various statutes in the contract would have defeated its purpose because statutes change from time to time. Whether or not these statutes would have changed would have been defeated had the language of the statute been recreated into the actual contract of the parties. And being a surviving contract, it was not the judge's job to make a better contract. The judge made it clear that she felt sympathy for Mr. Andrea because he had no avenue for ever terminating his obligation to provide his ex-wife with health insurance. But that is simply another error of law created by the lower court. A surviving agreement can always be modified, but at a higher standard. Rather than a mere change in circumstances, there must be something more than that. And something more is typically along the line that Mr. Andrea would either.
Mr. Driscoll, can we start with a more fundamental question? As I understand your first issue, you're saying that the dispute of material fact in this case is intent. Is that correct?
Yes.
I think you also state that there is no ambiguity in the contract. Is that correct?
That's correct.
My understanding of black letter contract law is that if there is no ambiguity, the plain language controls, and we don't look behind the plain language to discern intent. So how do you square your argument with at least my understanding of contract law?
Well, the judge made an error of law when deciding that the contract needed to be basically rewritten. It failed because the clause that was in the statute that was incorporated by reference was not included in the language of the contract.
I understand that, but again, you're stating that there is no ambiguity in the plain language. So therefore, it's up to us, de novo, to interpret that plain language. But my understanding is we don't get into the intent of the parties in that situation. Yet you're saying we have to decide intent. That's a fact question. Another way of phrasing my question is, aren't we supposed to be analyzing this just as a question of law? But you're saying instead, no, there's a dispute of fact. And I don't see how we get there.
Okay. It is a question of law, and the judge made the error at the time of temporary order, which was incorporated into her decision for the summary judgment. However, the only defense to that was if you take a look at the plain language of the contract, the intent of the parties is clear that Kelly shall have the benefits of continuation of medical insurance coverage as allowed under the following incorporated by reference statutes. There's one listed and others of that sort. So had the judge not decided the legal question incorrectly already before hearing summary judgment, then intent would have been the issue. But this comes at us backwards because the judge had already made the error of law before the summary judgment hearing and incorporated that decision into her final finding. She actually told Kelly that you're going to lose. I've already made up my mind. And that's available at the transcript at pages 8 and 9. That there was no reason to be here except to move this on to appeal.
I'm sorry. I understand your argument, and I know what you're referring to in the judge's ruling. I just want to make sure I have a correct understanding of another part of your argument. So Section 110B says, in relevant part, in the event of the remarriage, it goes on to state that the former spouse thereafter shall have the right, if so provided in said judgment, to continue to receive benefits, etc. So I think the key language there are the words, if so provided in said judgment. And your argument is that by referencing the statute, which is incorporated into the judgment, it has been so provided in the judgment.
Correct.
Is that the essence of your argument?
Yes, it is.
Okay.
The lower court would have us not incorporate that statute and others of that sort by reference, but would rather have parties create separation agreements that would include all of the statutory language at the time the agreement is signed. But if the intent of the parties, again, intent, is to follow the all benefits of continuation shall be available, for example, take a look at these statutes, none of which, by the way, would apply to these parties. Because all of the statutes, the one referenced, as well as other similar statutes, all apply to hospital, surgical, nonprofit hospital services. None of them actually apply to the party's situation, but they apply as an example for continuation of coverage. Hey, if he needs to come up with a rider, so be it. And that's what the incorporation by reference is intended to say. Now, should the legislature come by and change all of that language with new healthcare bills, saying that there will be no continuation of coverage upon remarriage under any circumstances, Kelly would also be bound by that new law because it was incorporated by reference.
So I take it your argument is that the last sentence of Exhibit B in the separation agreement was intended to secure to the wife the maximum, the full, whatever the full extent of statutory protections might be with her with respect to medical insurance coverage.
Yes, there was one statute listed, and then the language goes on, and other similar statutes, no matter what they are, no matter when they come into existence. She shall have all benefits of continuation of coverage. That also doesn't limit it to necessarily Massachusetts law. Though Massachusetts would follow the federal law as far as
all right,
health insurance.
so, but why don't we just be precise here? In this particular case, which statutes are you pointing to that she should have the benefit of?
Well, one is enumerated in the contract itself. It is
110, Chapter 176, Section 110I.
correct, but that's a Scrivener's error. It should have been 175.
Yes, Chapter 175, sorry.
Correct. That is the first example, as this and all other similar
But I'm
statutes.
asking you, which are you pointing to any other ones that she should get the benefit of in this case? Not just all of them, which specific ones? Is there any
That's
other
the
one?
issue. It's all other similar statutes now.
Which one did you argue below she should have the benefit of apart from 175, Section 110?
There was no specific other statutes argued outside of all similar statutes. But I can tell you that the judge in her decision included 176A, it didn't identify Section 8F. That's for non-profit hospital services. 176B didn't identify Section 6B, nonprofit medical services. And 176G did not identify 5A. That's for health insurance maintenance contracts as a party. None of those statutes actually apply to these litigants. However, they give the framework that continuation of coverage shall include every opportunity available to provide Kelly continuation of coverage. So those, at the time of divorce, and even today, those statutes don't apply directly to the Andreas, because Mr. Andrea and actually neither party are in the healthcare field. Mr. Andrea is in the insurance brokerage field. He works for, as his affidavit says, MIB, which can be found at MIB.com. And so None of those statutes were intended to ever say this statute's going to apply because it currently applies or may in the future apply to Mr. Andrea. It was merely to provide continuation of coverage at the greatest possible advantage to Kelly. And under the canons of construction, every word should have been given meaning without rejection. And what the judge did is actually reject the incorporation by reference, which is a long-standing. Judge Neyman?
Yeah, I'm just looking at the statute, and the plain language of that provision seems to state, if I'm reading it correctly, that the statutory provisions authorizing, quote, benefits for continuation of medical coverage, end quote, shall apply here. It's mandatory language. So in other words, the statutes apply regardless of whether or not the agreement, the contract, references them. So I'm wondering what was the idea behind simply referencing a mandatory statutory term in the agreement? Sort of I understand it. You're saying, well, it seems to me it's just reinforcing what is already a statutory right. I'm not sure what else it gets you. I'm trying to sort through that, if you understand my question.
Yes, the best I can figure since this agreement came into play roughly 10 years ago was that nobody knew in the future what continuation of coverage terms might be. So in order to afford the greatest opportunities, they said, look at the statutes. Here are some examples of statutes that provide continuation of coverage. It's going to be whatever they say at the time. And again, if the legislature came back saying there is no continuation of coverage after remarriage, Kelly would have been out of luck with this language. But it didn't change. So a rider is incorporated by reference into the contract. And if they said, if the language of the statute actually changed, saying that no rider was ever going to be required, that would also be incorporated by reference because it referenced the statute, not the statute as of the effective date of the parties' agreement. So it was actually a living continuation of coverage term. And what the lower court is trying to say, or has said, is no, we're going to interpret it as saying, if you don't include all of the language, meaning Part B of those statutes requiring a rider, if a rider is not specifically mentioned in the term within the contract, without incorporation by reference, then you lose. And I think part of the formula here in the judge's mind was the fact that, as we can see all along through the transcripts, that Mr. Andrea's argument was, it is inequitable for me to have to provide my ex-wife insurance coverage for the rest of my life. I have no way out. And the judge says, yes, you have no way out, but he did have a way out. Every contract can be changed. Separation agreement contract can be changed. He just needs to show more than a mere change in circumstances. If he lost his job and had no insurance, that would be a change in circumstances. The question is, does it raise to the level of a substantial change required to modify a surviving contract? So the judge also got that part of the law wrong. You can modify a surviving contract in a marital agreement. And the judge, in her decision, came down and said, no, you can't. And that's why we must do it here. We must release this man from his obligation because there is no other way at law we can do it. So the judge found a way.
I take it the relief you think the judge was required to give you was let's just modification of the judgment that would have been a rider permitting the wife to be added, the former wife to be added to the husband's current policy.
Correct to a point. The judge should have read the agreement, should have read the term medical coverage with all continuation options available. And in this case, the continuation option is a rider. She should have told Mr. Andrea, go get a rider, because that is what your contract says under the law.
So she wouldn't have needed to modify the judgment?
No, it would just have to be a directive.
She wasn't seeking modification.
Excuse me?
She didn't seek the modification.
No, Mr. Andrea
No.
sought the modification. So there was nothing to modify. It was merely an order to Mr. Andrea, the moving party, to go get that rider and deny his motion for his complaint for modification. And if in the future he has a substantial change in his circumstances that would warrant modifying a surviving agreement, come back to court. But at this time, he does not, and the judge never addressed that issue. She didn't even know it was a possibility. I see my time's expired.
Thank you.
Thank you, Your Honors.
Mr. Heinley?
Good morning. May it please the court. I represent Ralph Andrea, the appellee in this matter. Piggybacking off of the conversation that just ended before my time began, I think it's important to note that what Mrs. Andrea sought at this hearing, at the initial hearing, was to have Mr. Andrea's request completely dismissed at the trial court level. She did not come before that court asking for the judge to simply recognize that she, under this agreement, would have had rights to a rider on his plan. She asked the court to completely dismiss his request to be able to remove Mrs. Andrea from the plan and enroll so that he could enroll his new wife. And if we're relying on the statute and the plain language of the statute, the first paragraph of that statute, subsection a, actually provides the exact remedy that occurred here, which is that upon the remarriage of the subscriber, which here is my client, the secondary spouse, the divorced spouse's coverage terminates. That happens by operation of law under the statute and actually doesn't need an order from Judge Gorman. That happens, as Justice Neyman pointed out, that statute applies whether this is referenced in the agreement or not. The only way that Mrs. Andrea has had post-divorce coverage for 11 years following the divorce on this employer-based plan is because of the existence of Section A of this statute. What they did not do was follow the separate and distinct requirement in subsection B, which in plain language requires the parties to provide for a rider or an additional contract in their divorce agreement in order to ensure those rights. By not,
what do you interpret the language in Exhibit E of the separation agreement? The last sentence, the wife shall have all benefits for continuation of medical coverage as is allowed under general laws, chapter 170, 175, 110I.
to do exactly what happened here, which was to continue Mrs. Andrea's coverage for 11 years post-divorce on Mr. Andrea's plan, and that's exactly what happened. She
But it says
received
110I, it doesn't limit it to A. So if 110IB says continuation includes a rider, why does it have to say rider where she's entitled to all benefits for continuation?
because that's what the legislature required her to say in this agreement, and she failed to do so. A rider is not a continuation of a policy, and the issuance of a separate insurance individual contract is not the continuation of coverage. Continuation on the plan is exactly what Mrs. Andrea received for the last 11 years. A rider.
I want to ask you a question. So the Exhibit E seems very confusing to me. To begin with, Section 1, Paragraph 1, is entitled medical insurance, and that is an unrestricted obligation on the husband to provide medical insurance to the wife. If we looked at that section without reference to section 2, which is called uninsured medical expenses, would you agree that the husband's obligation is absolute and continuing and not restricted by whether or not he gets remarried? Or are you saying even if we just look at section 1 by itself, the statute, section 110I subsection B, would terminate her eligibility for medical coverage?
So I would say it's the latter, but I would say it's actually.
But then why do we need the reference down below? What does the reference down below then add?
I don't think it adds anything, and we see lots of superfluous language in this agreement and many divorce agreements every day at the family court, including when people refer to the equitable division of their marital estate pursuant to section 34. There is no other statute it can be pursuant to. There's no reason to reference that, and yet we see that type of annotation every day.
Okay, so let's assume we're not going to read it as superfluous language. And let's also assume that somehow we're going to read it as not being just limited to the paragraph 2 that it appears to, but is somehow relating to paragraph 1 that it doesn't appear in. All right, it says, as Justice Lemire pointed out, it does not read to me as though it's intended to restrict the wife's medical coverage. It reads to me as something that is confirming or maximizing her entitlement to benefits, because it says the wife shall have all benefits. It's not worded in a way to restrict anything that comes before. Do you see what I'm saying?
I agree and I understand.
All right. So in that case, combined with the fact that it refers to the entire section 110I, it's not limited to A, not limited to B, why is it that she's not entitled to the benefit of being added to a rider on the policy?
Because the exhibit that we're looking at here in their divorce agreement requires him to maintain his insurance obligations to her, not to provide. And in maintaining the existing group employer provided plans, she received the exact continuity of coverage that section A, read in its broadest possible manner, which I agree with you, the words all rights of continuity of medical coverage, reading that in the broadest possible way for Mrs. Andrea's benefit, which the trial court would have to do at a summary judgment hearing, she received exactly that broadest interpretation. A rider or the issuance of an individual contract, which is what section B talks about, is not a continuation of the existing family plan. It's a separate issuance of a separate right to her, which she did not contract for, even under the broadest possible interpretation of that statute.
Okay, but
section B does include continuation. It uses the word to continue, to receive benefits.
If the agreement so provides by name, which I would respectfully suggest didn't occur.
Does it, if so provides by name?
Because it says that if
it's provided in the judgment. And what we're suggesting is that language on Exhibit E provides it.
I understand. In reading it in the broadest possible terms, I do think, and I argue this in my brief, that the best possible outcome here for Mrs. Andrea is the issuance of a rider at this point, so that Mr. Andrea can enroll his current spouse on this plan. That is, I think, the best possible outcome here for Mrs. Andrea. What she was arguing, both in the brief and at the lower court, however, if you look at the transcripts, is that and in her affidavit she submitted to supplement the record, is that Mr. Andrea signed up for a lifetime obligation for her in a survived manner to provide her with insurance coverage.
Well, are you saying because she has not moved to have a rider or an individual policy in place, that's why it hasn't happened?
No, I think what should have happened, it's very clear to me that Mrs. Andrea doesn't want a rider. What she's looking for is rights expanded beyond that, that require Mr. Andrea in a survived manner to provide her insurance for the rest of her life. She says that in—
How are we to know that that's, because I heard your brother say something different today. How are we to know that that's not what the wife wants? That she doesn't want a rider.
I did hear my brother say something different today, and was intrigued by that, because what was argued at the lower court and what was argued at least at times in the brief and in the affidavit that Mrs. Andrea provided to this court is that she exchanged a survived waiver of alimony for Mr. Andrea in direct consideration for a survived benefit of him providing her with insurance by any means necessary. And that is a position that is flatly contradicted by the language in the front of their separation agreement that says Mr. Andrea's alimony waiver was negotiated in concert with his picking up the college expenses. So yes, I agree with you. My brother said—
Is your client willing to provide a rider?
No, he's not willing to provide her a rider and pay for it because that's not what they bargained for. If what this court determines is that Mrs. Andrea is entitled to the issuance of a rider, she certainly would have the right to do that under the statute as it exists today, but on her dime. My client paying for a rider for her for the rest of her life cannot be the interpretation of this contract as it is written. At best, it is read in the light most favorable to her in a summary judgment lens. It might provide her the right to a rider, but it does not provide her that rider at Ralph's expense. The agreement doesn't say that, and the statute doesn't say that.
So this seems to me to then circle back to the question to whether what we are doing is being asked to interpret something as a matter of law or a matter of fact. I have to say, I read this and it is not clear to me that this is an unambiguous contract, and it's certainly not unambiguous to the degree that you both seem to be arguing. On the one hand, that it provides for a rider but doesn't provide for payment, or that who has to pay for that rider. Can you help me with that? Is this purely a question of law, or would this need to be remanded? If we were to conclude that the reference in the, first of all, I take it if we were to conclude that as written, this section of the separation agreement were ambiguous, then you would agree that it would need to be remanded for further proceedings to determine the meaning. All right. And if we were to conclude that the reference provided for unambiguously to incorporate the benefit for the wife's benefit, all provisions in section 110I, including the possibility of going onto a rider on the husband's policy, then your view is that it would be needed to be remanded for the question of who would pay for that?
No, I think it's clear that it could be remanded for the question of payment, but I would argue that the agreement, by not calling for Mr. Andrea to pay for it, is clear that that's something Mrs. Andrea, if given the right by this court to do, would be her prerogative and her responsibility. But it's certainly a question that could be remanded, I suppose. Right.
How would we reach the contrary conclusion? Well, I guess it's this. You say so. I guess you would say that that flows from the use of the word maintain in the first paragraph of the separation agreement, that because adding her to a rider is not, quote, maintaining her.
Correct.
Then it follows that if she's added to a rider, it comes at her expense.
Correct. And the fact that this falls under the uninsured medical expenses, that would be, in that section 2 in their exhibit E of their divorce agreement makes clear that they are each responsible for their own uninsured medical expenses. If we read this literally, where they put this provision in section 2 of exhibit E, then she's responsible for that as an uninsured expense. I will acknowledge that the placement of this sentence creates problems for both parties, quite frankly, I think, and neither my brother, my friend and colleague, Mr. Driscoll, nor I were around at the time of this divorce and drafted this agreement, but I can tell you that I think the placement of that sentence creates problems for everybody in applying this. But if we are to look at it unambiguously where they chose to place it in the contract under uninsured medical expenses, that paragraph also makes clear that they are each responsible for their own costs in that regard.
All
So
right. Well, seems to me to be a new argument that no one's seen before.
and I would be remiss if I didn't concede that this agreement has its problems, but I don't think that that those problems require unraveling both it and the application Judge Gorman saw fit to apply it to the statute through summary judgment. She had already written a detailed decision about this. She incorporated that into her thinking, and judges are allowed to enter summary judgment without holding lengthy oral argument. They can do it on the papers under Rule 78 if they want. So she had already laid out her thinking. Choosing to not do so again, I think, was simply a matter of judicial economy, and she's given an enormous amount of discretion with so-called jump balls like this in the probate court at the trial court level to call it the way she sees it. And I think that's exactly what she did against the way that she read the plain meaning of the statute. And I would respectfully suggest that the discretion given to her is certainly wide enough to uphold her decision here, regardless of, and if she had come down against Ralph, I think she would have had the right to do that too.
I have one last question. I'm sorry to catch you right at the end of your time. The way I read the statute, particularly in the context of the chapter in which it appears, is that it's directed towards insurance companies. In other words, that the statute is talking about eligibility as opposed to restricting the ability of the parties to contract with respect to medical insurance as they see fit. Do you read the statute the same way?
Yeah, yes, I think what it was ensuring was that insurance companies would understand that they had an obligation to carry an ex-spouse. I think that's clear from Section A of 110I, is that it is aimed at group plans through employer-based group
right.
plans.
So it's not intended to curtail or restrict whatever the parties may have bargained for.
Well, I think parties, not only under this statute, but in the probate and family court generally, have enormous latitude to contract in different ways, and they choose to do so every day. And an example is found in this agreement where they swapped an alimony waiver for a college expenses payment. That's not something the judge would have necessarily ordered. It's something they chose to do. And I think they could have and did whatever they chose to do about health insurance here as well. I think the statute was meant to say to the insurance companies, divorcing spouses shall have certain continuity rights. And then as we see in Section B, they were a little more specific about providing for certain additional rights beyond just continuity of coverage in the form of a rider. If so,
this is directed to the insurance companies, and then whether or not the parties decide to contract to take the full benefit of it or not, that's sort of up to the parties in their agreement.
If they choose to settle their case, yes. If it had gone to trial and judgment issued,
right.
Yes, that would have been a different analysis.
Okay, thank you. That's very helpful to me. Does anybody else have any other questions?
Thank you.
This is a very interesting case. We really appreciate your arguments, which have been thoughtful and helpful to us. And the case of A FRENIER and another versus Juliano Enterprises, Inc., case number 2019 P1682. And Attorney Galvin, we're ready whenever you are.
Good morning. May it please the court. My name is Attorney Robert Galvin. I represent the defendant in the underlying case, who is also a plaintiff, Juliano Enterprises Incorporated. Just briefly on the facts, and I know the court is aware of the facts from the filings. Juliano Enterprises acquired the subject property back in 2006. In 2006, there was a 21E conducted oil or gas. Mr. Juliano, on behalf of the company, went to begin building a building on this site, which has three actually building pads, and they discovered urban debris. The evidence at trial was that Mr. Juliano then hired a licensed site professional, HML Associates, and Tedeschi Realty Corporation by a change order to remove the area of the additionally discovered debris for an additional $76,000.
May I ask you a question? Are these all, is this one lot with three building envelopes, or is it three separate lots?
It's one lot, Your Honor, with three separate building pads. So when it was originally permitted, there were three separate building sites on a lot, and it's technically a condominium. So if that's the best way to look at it, okay. The plaintiffs in this T or FRENIER and Solmonti bought the second pad site, and it's been subsequently assigned a street number of 1322 Belmont Street, although technically it's all on one property. So what they did is—
Can I ask you a question, Attorney Galvin? Was there any urban debris found on this second building pad in connection with that building of your client's building?
Yes, there was, Your Honor. There was 2 test pits drilled in the location where ultimately the CCRT building was ultimately constructed. And, you know, it was the work that was done under the supervision of an LSP, HML Associates, and the work was actually performed by Tedeschi Realty Corporation, which charged that $76,000. So
when your client bought the property, were any of the building pads constructed on?
No, Your Honor. It was, as far as he knew, a previously undeveloped site. There was a 21E report that didn't disclose any history of oil or gas contamination. And he built and started building the first building, which is now known as 1324 Belmont Street. And that's when they discovered this. They did some tests across the entirety of the site. And that's when the urban debris, which was basically it's trash that was buried probably from the city of Brockton or something like that on the site. And it had been there so long, no one knew about it. So
I think at trial there was an Exhibit 5 that identified the locations where testing was done, and I'm not sure if it indicated where clearing of the debris was performed.
Your Honor, that's exactly the case. There was.
I don't see that in the appellate record.
You know, I looked at it again this morning and I didn't locate it there, so I agree with you. What I will tell you, though, is that Mr. Giuliano planned to build his own building on that site, and at some point changed his mind and decided he was going to sell that pad site. And this is the site that was ultimately purchased by Mr. Solmonti and Ms. FRENIER.
But Judge Rasuti would have seen that evidence.
He saw that evidence, Your Honor.
And I'm not sure if it clarifies, because in my mind, I have no idea what Tedeschi cleared when they did the remediation of the trash.
Yeah, the only evidence at trial, Your Honor, because Tedeschi Realty Corporation ceased to exist many years before this trial took place, was that Tedeschi, according to Giuliano, Giuliano testified that they dug where they could and or where they were directed to do, and he wasn't involved, and he assumed that they dug everything out that they were directed to dig out based on the HML Associates guidance. So I highlight that fact because I think that relates to the ultimate legal issues. I don't think there's any dispute of fact, and it wouldn't be something that I think I could really argue. Mr. Giuliano clearly acknowledged that he stated that the site was shovel ready. He did make a statement to the effect that you never know what you're going to get if you dig elsewhere. That's uncontradicted and corroborated by the evidence. But what happened in this case is they signed a purchase and sale agreement after about 6 months of negotiation. And it wasn't a standard form purchase and sale agreement, and you have that in the record. An additional rider added onto it. Both parties were represented by counsel. CCRT had a construction consultant, CWB, and it added a specific clause in it that said that they were not relying on any representations. And the evidence, which I think is also undisputed, is that the 21E report itself, the one that Giuliano bought with and didn't discover the urban debris with, was also produced to CCRT. And there was no due diligence done. There were no guarantees added to the purchase and sale agreement. And the parties went off and began the construction of the building, at which point it was discovered that there was additional urban debris in some portion of the footprint of where CCRT building was going to be located.
So was there any discussion or any evidence of discussion regarding this clause about no non-written warranties included? Is there evidence about that, and whether and does that evidence show that they specifically negotiated regarding this shovel-ready statement?
Well, other than my client's own statements, I would say no. I will tell you, though, I didn't raise this as an appellate issue. I did actually attempt to have Attorney Domenico, who was the trial attorney, but also the attorney that was involved in the negotiation of the purchase and sale agreement, testify, and that was refused by the court. So it was nothing other than what my client testified to. So I would move ahead from that. But in terms of the legal issues now, I mean, we know that there was subsequently discovered urban debris. My client admits to making this statement because it was in writing that it was an unforeseen condition. There was a change order.
You keep freezing up.
Which was, I apologize.
I just heard you say there was a change order.
Yes. After the discovery of the urban debris, pursuant to the construction contract, if you discovered a latent defect or any of an adverse site condition, a change order was required, and the parties actually signed a change order to the contract. They estimated the cost would be $50,000 to remove the urban debris, and the parties agreed to split the cost, and it ultimately turned out that cost was about $72,000, which my client actually paid his share. So in terms of the legal issues, I think where the court, Superior Court, erred as a matter of law was it attempted to apply law that relates generally to fraud, but didn't apply any of the law that the court has applied to purchase and sale agreements in the sale of real property, which still has caveat emptor involved. And I don't think that
are you suggesting, so the caveat emptor, does that trump a fraud claim? You know what I mean? I don't mean to make it as simple as that, but I mean, the judge found specific facts that he says constitutes fraud.
I agree.
You know, he didn't credit that it was unforeseen. He felt they withheld the information about the trash being remediated previously. So he found evidence of fraud. Does fraud trump any other contractual?
I think it would, Your Honor, and I would concede that. But I think the judge's findings were actually
You keep freezing up.
Contradictory. Okay. I really apologize.
No, it's not. It's
okay, because when you come back on, we do catch up. It does tell us what you said.
Okay, so what I was trying to say was, I think the judge's findings are contradictory because he actually found that Juliano had no actual knowledge of any remaining contamination. And where he tried, where I think the court erred was, he tried to make the finding that Juliano still had an appreciation of a serious risk of further contamination, but he actually found that there was no actual knowledge. And you find the negligence and fraud findings throughout the judge's findings. And I think that's—
Can I stop you there, counsel? I mean, can't there be fraud if there's a reckless disregard for the truth, which is what the judge seemed to have found? That is, your client didn't actually know that there was debris on lot 2 still remaining after the remediation, but given that there were so much trash during the building, it was reckless to say this is shovel ready, and certainly reckless to say this was unforeseen.
Well, I think that's clearly what the court attempted to do. I think the problem—
And why is that contradictory, though?
Well, because he actually made a finding that Juliano had no actual knowledge of any remaining urban debris.
Right, but isn't that wouldn't be required for recklessness? That would be not just reckless, that would be deliberate. So But we're talking about, I think Judge Wendland's question goes to recklessness, which wouldn't necessarily require actual knowledge of debris on this portion of the lot.
But we do have a case called Underwood versus Reisman, and that's a case where the 3 that liability based on a suspicion or even a likelihood is not actionable. And that's in the context of this type of a case. So that's why I say that it's not proper to make even a finding of recklessness on that basis. And if you look at the case law that the judge applied, it was Noda versus Keys. That wasn't even a case where there was a seller and a buyer. That was a case where there was an architect whose job it was to identify the amount of ledge to a subcontractor, didn't do their job appropriately and misrepresented the actual quantity. So I think that's where the major disconnect in the case is. The next disconnect, I think, lies in the fact that even the judge acknowledged that the statements that Juliano made were one of quality, which are typically not actionable. And they're not actionable in a case specifically where the buyer has the absolute right by any of the statements. This buyer acknowledged on the stand, and the evidence was they didn't even ask what shovel-ready meant. They just assumed what it meant. And, you know, again, this is a sophisticated commercial purchaser. And I think the case law is very clear. The Kabachnik case is that people often overstate the quality of their land. And in a commercial setting, particularly in a commercial setting, these are things that a buyer had a right to evaluate.
But the judges made these findings, and they seem supported, at least factually, based on the record we see. So you want us to disregard the judge's findings?
Well, because I think the judge incorrectly applied the law.
All right, so you're not asking us to disregard the findings?
I am not asking you to disregard the findings. I think the judge just respectfully didn't apply the correct law. And I think that the law that we have here clearly compels the result that that Juliano Enterprise did not do anything wrong, and the burden fell on the buyer in this particular case to verify any statements they wanted. And in fact, they specifically disavowed that they were relying upon any of these statements.
Before your time completely runs out, I'm hoping that you can turn to the question of damages.
Yes, I'll actually skip right ahead to that because I think the other issues are properly briefed. In this particular case, the fraud, if at all, had to do with the urban debris. And we know that that cost $76,000 to remediate. We know that Juliano accepted responsibility for that because they paid for half, CCRT didn't. What happened is, if there was a fraud in this case, the $76,000 or their share would be their actual damages. And complete the building, which arose out of a completely different set of circumstances after there was even a change order specifically addressing this. The fact that Mr. Juliano said it was unforeseen conditions could be fully evaluated. They had counsel at that time. They elected to make a change order. I say a subsequent parting of the ways 6 months later, as a result of a completely set of circumstance, is not benefit of the bargain damages. So I really don't think that's appropriate in this type of a case.
Would you agree that it would not just be limited to the cost of remediation, but let's just say the cost of delay, yep, or any incidental costs, whatever there might be in response to, you know, as a result of the...
I think that those types of damages would also be recoverable. There was no evidence of delay damages in this particular case. So, but I do agree that those would flow directly from a potential fraud. There just was no evidence of anything other than the 76. And I really think it's a disconnect. There's so much time that elapsed in completely different set of circumstances 6 months later. Thank you, Your Honors.
Thank you. Mr. Curhan, Attorney Curhan.
May it please the court, Dana Curhan for the appellees. The judge made specific findings of fact, which my understanding is the appellant does not challenge. Those findings clearly support if not an intentional misrepresentation, clearly a reckless misrepresentation. There is really no room to find that this was simple negligence.
Attorney Curran, you can use your time in whatever way you want to. I'm personally interested in your response to the last thing that your brother said with regard to damages and why the damages relates to something that occurred, as he said, 6 months later.
Well, it wasn't something that simply occurred 6 months earlier and that was over.
May I? I'm very sorry to do this. I may have an emergency right here. I think the police or the fire may be at the door. I'm so sorry, but I just need to pause for 1 minute.
That's fine.
Why don't we go off live and
All right, we are live and recording.
Thank you. I apologize for interrupting argument. We've reset the clock to 15 minutes, Attorney Curran, and you may proceed. And again, I apologize.
Let me get back to Justice Wendland's question. I think this wasn't a misrepresentation that happened at the beginning of the contract and that was it, and nothing further happened. This was a series of ongoing misrepresentations. When the trash was discovered, I believe the email from Mr. Juliano was, we found some quaking at part of the foundation site, probably caused by groundwater. Now, at the time he knew that there was trash here, and, he had reason to know that there was trash. There was a strong potential for trash throughout the site. My understanding is that there was.
When do you say was the last date by which your client knew that there was trash on the site?
I'm sorry, that my client knew, or that Mr. Juliano knew?
That your client knew.
He got some inkling when there was a report from the soil company that there was trash, and he also, there was some sort of oblique references to prior remediation.
Well, he certainly knew by the time they're negotiating for the cost of remediation.
I'm not sure if he would have known that, that there was a real potential for there to be trash on his site.
Well, then what were they negotiating to remediate?
Well, they were negotiating to remediate trash.
Right.
But the the question is, when would the judge have, or when would Mr. Suleimante have understood that he had been lied to, that there was a strong potential.
Oh, but I didn't ask about that. I asked, when did he know that there was trash on his site?
Sometime around shortly after it was discovered.
Okay.
And of course.
So once that's the case, and that was not an ongoing, once he knew, why isn't that pertinent in some way to the measurement of damages?
Well, what happened after that was Mr. Juliano continued to make misrepresentations about his knowledge and that this was something that was unforeseen. And the judge found that it was not unforeseen. But he continued to say, well, look, stuff happened.
But how does that affect his damages?
How that affects his damages is it really destroyed their relationship. And once, as Mr. Suleimante started discovering that he had been lied to, and that after discovering the trash, that Mr. Juliano continued to say, well, look, we discovered trash and it's unforeseen and it's your responsibility. And that was really, those were ongoing false statements that continued throughout that summer. And and as things went on, and I'm not sure if we have a specific date when he knew that,
What was, can I stop you? I'm sorry. What was
Sure.
the bargain that your client struck? That is, you're seeking benefit of the bargain damages. And it seems to me that the bargain that your client struck was a site that was actually shovel ready, free from this trash and debris.
with the building constructed on it for a certain price. And
Right,
the-
but that last part is not the subject of the fraud claim here.
It's not, but it,
The bargain was a purchase of a building on a site for
yes,
1.1 something, almost
Right.
1.2 million. And I guess what Frenier is saying is that the lying, the misrepresentation, caused the erosion of the relationship, resulting in a changing of contractors and an increase of price of $300 and something thousand.
that's pretty much it. I don't think it was that much, but it was close. But it was around that. But I think what happened was, at the time, my client discovered the fraud. He probably could have walked away from the contract, gotten another contractor and had it finished. He stayed with them for a few more months until at some point in November, and you'll see the email in the record appendix, Mr. Juliano said, look, if you want to go get another contractor, go ahead, because this relationship is pretty much shot. And I think maybe he was hoping for a reset, but Mr. Solomonte took him up on that and went and got another contractor and finished the project. And, there was some additional cost there. So I think that is directly traceable to the fraud that had gone on since the beginning of the contract and going through the middle of the summer. It's sort of ongoing fraud.
How do we know this? Let's say that your clients had not decided to terminate the contract, but had remained with Juliano's company for the construction of the property. Where would be the damages associated with the acts that the judge found constituted fraud in the inducement, other than the cost of remediating the trash?
Well, I mean, there was certainly a substantial delay in completing the building. And
What
that
was the evidence on the cost of that delay?
There was no evidence on the cost of the delay.
Okay. So besides the delay, what else?
That's possibly it. I mean, the thing
What
is,
about, weren't there some materials that were left in the open that had to be replaced?
there were some materials, but we didn't get credit for that because the judge found that, that was the subcontractor's responsibility, and had Juliano stayed on the job, he would have been able to get reimbursed for that. So we didn't get.
So my question is trying to get to causation, which is, how do we know, or how can anyone know, that the additional cost for completing the building with the new contractor is caused by anything Juliano did or any of the statements Juliano made or didn't make regarding the site, as opposed to caused by the decision to switch horses midstream in the construction project?
Well, I mean, the contract actually took out a clause that allowed the buyers to change contractors without cause and with just notice. That was taken out, and the relationship, there is evidence that the relationship became so bad that Mr. Juliano said, look, the relationship is that bad, and you don't trust me, and you don't think I'm competent, and if you want to get out, you can get out. Now,
but he didn't say, if you do, I'll pay for the construction of your building.
He didn't say that. No, and there was no discussion about that. Maybe there should have been some discussion about that, but there wasn't. But I think it was clear, and I think the judge could find that the misrepresentation, the fraud was sufficiently, was a cause of the breakdown in the relationship, to the point where Juliano himself suggested that he get another contractor.
And
So
you're
I-
saying
The fraud was
price
not.
that- Sorry.
Go ahead, Judge Wendlandt.
So you're saying the price that Juliano pays for offering that option, which had been taken off the table, he put it back on the table, is the cost of paying for the new GC?
Well, it's the difference between what it costs to complete the building and the
So Juliano
What
gave
Juliano would-
something to your client for free, and you're saying that it's costing him that difference? That you're
Well, I don't
entitled
know.
to that difference?
I don't know if it, I think if Juliano said, look, we're just not getting along for reasons that are sort of unrelated to this misrepresentation. If he said that, if he said, look, I don't like working in the winter, or I don't want to do this, or I don't want to do that, that would be a different story.
Well, he did. The email gives a whole list of reasons, and none of them has to do with the remediation or the trash.
Well, I think it is traceable to the relationship, to the breakdown in the relationship found by, which the judge found, and which was relating to the fraud.
I have a factual question. Does any of that difference in costs include this EFIS system?
No, I think the judge took that out.
Okay. So it's just the labor.
It's just the additional cost. Essentially, that would be it. And you know, my client had to get a contractor who was actually a client and say, look, come in and save this and get this building done. We were expecting to move in January, and that obviously isn't going to happen. You know, part of the reason for the why my client was upset was that he never, the 4 months that it took to remediate the trash, obviously it created a delay, but Mr. Juliano never said, hey, this is going to push back our schedule. And so prior to this email, or around the time of this email, Mr. Suleimante said, look, you know, what is this going to do to the schedule? And Juliano, you know, then did his email, you know, we're not going to, there's a series of emails, but no, we're not going to meet the deadline, and our relationship is damaged. Now,
What's your best legal authority for the proposition that you get, that your client gets damages for this breakdown in the relationship caused by fraud in the inducement? Because it seems to me that's a really broad proposition. Anytime you hire a contractor to do something and then there's a breakdown in the relationship and you thought it was all going to go swimmingly, you get damages for it.
I don't think you get damages for a breakdown in the relationship.
Just because it's tied to the fraud in the inducement. In this case, you're entitled to it?
Well, it's fraud in the inducement, and it's ongoing fraud. And the ongoing fraud
is calling it unforeseen.
Calling it unforeseen and saying, yeah, you got to pay for it, too bad. And then, you know, ultimately saying, well, I'll pay for half of it. But
if we were to disagree with this theory of damages, what, in your view, would be the relief here? Is it that you could, that we would remand, I mean, I take it your client paid for half of the remediation costs, or ultimately they did not?
They paid for half. It was $23,000. They got part of that $300-something thousand in damages included that, and it included doubling that under 93A. And the rest of the damage award was for the additional cost of constructing the building on time.
So you would say that even if we disagreed with the award of damages for the construction costs made after the decision to terminate, that you would still be entitled, your client would still be entitled to the half of the remediation costs it paid and the 93A damages associated with that piece?
Absolutely. But I also think, I don't think you can divorce the, what happened later from the sort of ongoing fraud in this case. And these are all really based on factual findings, not necessarily rulings of law. And I think the Giuliano does not challenge the factual findings, and nor could he. I mean, there's no clear error here. And going back to whether it was foreseeable and whether it was mere negligence, Giuliano felt sufficiently concerned with the possibility that there was trash in this property that he had test holes dug, and on a couple of them on the property that is now my client's property, they found trash. Unless there are any further questions, I'll leave the remaining points of the brief.
I'm all set.
Thank you both. Again, I apologize for the interruption. It was a very helpful argument. It's an interesting case and the case is submitted.
Thank you.
Thank you, Your Honor.
All right, we are live and recording.
Good afternoon and welcome to this sitting of the Massachusetts Appeals Court. Your panel is Justice Neyman and Justice Lemire and myself, Gabrielle Wolohojian. Although we're doing this argument in Zoom in this format because of the pandemic, all the ordinary rules of argument in our court apply, including that each side will have 15 minutes to argue and there is no rebuttal. With that, I'm going to call the case of Lynn A. Cheek versus Raymond G. Cheek, case number 2020P0141. Mr. Cheek, we're ready to hear your argument whenever you are.
Thank you. I appear before this court today to ask if this court will review 4 of the decisions in the judgment of divorce Nisi dated June 19, 2019, and amended on October 21st, 2019. It is my position that the trial judge abused her discretion in determining these decisions. Regarding the decision that my Massachusetts General Law, Chapter 32, Section 7, accidental disability retirement allowance is a marital asset, the judge abused her discretion and made errors of law because nowhere in her findings or rationale is there evidence that the trial judge gave consideration to my argument that my allowance is by reason of personal injury sustained while in the performance of the duties of my job. It is clear what the intent of the legislature was because they made the distinct point to say that the allowance was by reason of personal injury. I presented my argument to the trial judge as instructed at trial, Record Appendix page 529, lines 10 through 18, with my proposed rulings of law, proposed judgment, and my rationale. Record Appendix page 54, 55, and 57. The trial judge gave no indication that she considered interpreting and applying the provisions of Chapter 37, Section 7, and Chapter 32, Section 8, evaluations and re-examinations of members retired for disability, as she is duty bound to do according to the Massachusetts Judicial Code of Conduct.
Mr. Cheek?
Yes, ma'am.
You don't cite a case called Warnichus versus Warnichus. I don't know if I'm pronouncing it correctly, in which a previous panel of the appeals court held that even if a retirement benefit, and in that case it was a worker's compensation payout, is based on personal injury, it still can be included in the marital asset, in the marital estate, and divided.
Okay, I understand that.
Okay, so why is it that this pension should be treated differently?
Well, I think it should be treated differently because the intent of the legislator, which is the clearest look into the mind of the legislator, the statute, Massachusetts Chapter 32, Section 7, and Section 8, makes it clear that personal injury is the reason for the Section 7 disability. Having said that, that sets things apart differently. And I'm not saying that the complete retirement allowance is not a marital asset. I'm saying a portion of it that relates to me as the injured party is not a marital asset. I don't know if that answers your question or not.
Well, you would like us to break out the pain and suffering aspect of it, I take.
I'm sorry, I couldn't hear you so well.
Are you trying to ask us to break out the pain and suffering aspect?
Yes.
And where this is a retirement allowance for an early retirement at whatever the percentage was, I want to say it was 72% for lifetime. There was no breaking out of any kind of either like in a judgment where there might be some evidence of pain and suffering and medical expenses and things of that nature. So this is a separate retirement calculation that does not necessarily break out or include pain and suffering. And if it does, could you tell us how we're supposed to determine that?
Okay, well, first, I think the pain and suffering part comes in with regard to Chapter 32, Section 8, evaluation and examinations of retired members who have retired from disability. In that section, it clearly calls for evaluations and examinations by physicians, or else to continue to have the member stay on disability. Because if there is no continued disability or suffering that renders the member unable to perform the duties of his job, the member, according to Section 8, Number 2, Part 2, would have to be returned to work. With regard to the breakdown, I tried to research cases that would show a Section 7 disability retirement allowance being determined to be a marital asset or not. And I could find none. The only thing I could find was D'Alessio v. D'Alessio. And I think that lays the framework for the division of the marital asset in this case.
Sheikh, to what extent is this argument contingent on, let me rephrase that. Does this argument depend on the evidence that you submitted in the form of the medical records?
Yes, it does. And
now, let me ask you, I'm sorry to interrupt you, sir. Just to finish my thought, my understanding is those medical records were not submitted to the trial court, but they were submitted in essence as exhibits appended to your appeal. Am I correct about that?
Yes.
Okay, so tell us what to do about that, please.
With regard to that, give me one second. Excuse me, my position is two parts. As a self-represented litigant, I ask the court to make a reasonable effort to consistent with law to facilitate my ability to be heard in accordance with the Massachusetts Judicial Code of Conduct, Rule 2.6. My position is also that in Doherty case 222, Massachusetts 98 of 1915, pages 98 through 99, makes an allowance for the court to exercise its discretion to allow the evaluations and examinations in as evidence. If this court does not decide to exercise its discretion to allow the evaluation and examinations in as evidence, I ask that the court consider the case to be remanded to the lower court so that I may move to have a hearing for the introduction of further evidence, and that if my motion is granted in hearing new facts that will show upon the point in question, the case should be considered anew upon all the evidence introduced.
Thank you.
Does that answer your question, or?
It does answer my question. Thank you.
Thank you. As I said earlier, I tried to find a case where Section 7 accidental disability retirement allowance was found to be or not to be a marital asset, and I could find none other than D'Alessio v. D'Alessio, 409 Mass 821 in 1991. In D'Alessio, the court decided that part of the personal injury award was not a marital asset. My position is that the lessee offers an equitable, fair, and balanced approach that does not cause an undue hardship to me as the injured spouse and lays the framework for the division of the marital asset in this case, because an accidental disability retirement personal injury allowance is analogous to a personal injury award. In both instances, a party is being compensated for losses. In the lessee, the personal injury award was viewed as compensating the husband for 3 distinct losses: past, present, future pain and suffering, past, present, and future medical expenses, and past, present, and future loss of earning capacity. The court designated 1/3 of the award to the injured spouse as compensation for pain and suffering, and the remaining 2/3 were for medical expenses and lost earning capacity and were a marital asset. In my divorce case, there are no medical expenses, as the Boston Retirement Board bears the cost of all the medical expenses related to the personal injury. That leaves just 2 losses. One loss that stays with me as the injured spouse as compensation for pain and suffering, and the remaining loss for lost earning capacity and as a marital asset. Standard for review on this decision is de novo, clearly erroneous, and abuse of discretion. Regarding the decision that each party will be responsible for the liability set forth on his or her trial financial statement, my position is the trial judge abused her discretion and made errors of law in determining that $377,486.80 of the $378,596.15 liability listed on line 11 of my trial financial statement is an IRS tax liability that is my responsibility. Record Appendix page 106. The IRS tax liability, Record Appendix page 198, resulted largely from the sale and associated capital gain of a rental property sold on March 22nd, 2006. Record Appendix page 216.
Am I correct that that property was, you were the sole title holder on that property?
Correct. Correct. But throughout the marriage, we had purchased and sold properties throughout the marriage. And whenever we did so, the gain or loss, and I will just say there were a few losses, but the gains and or loss was reported on our joint tax return as a capital gain. So I say that to say that that gain would have been reported as a capital gain had a tax return for the 2 parties been filed for the year 2006.
Which it wasn't. And,
Which it wasn't.
And it hadn't been for a couple years beforehand, correct?
Correct.
So why was the judge required to I guess, deem this one as why was the judge required to think that this 2006 tax year return needed to be a joint filing?
Well, that was because when a married couple fails to file a tax return, the IRS chooses married filing separate as a filing status when the IRS files a substitute tax return in accordance with the IRS's Internal Revenue Manual, Part 4.21.1.24, number 12, titled Married Filing Joint Election for Non-Filer Cases. And this is what happened in this case. This designation is shown on trial exhibit number 39, Record Appendix page 224, as Code 150, substitute tax return prepared by the IRS. However, the trial judge stated that I do not think that I am bound by what the IRS decided to do. That is on Record Appendix page 537, line 12 through 13. In my opinion, that's a clear failure of the trial judge to reflect the consideration of and to interpret and apply applicable legal principles. The IRS filing designation does not change the fact that
well, all right, let's say that you're correct. Let's say the judge was required to accept that the return would have been jointly filed. Can't the judge nonetheless allocate, I don't see why it means that the judge is required to allocate the debt on that return 50-50?
Well, because
the judge is just supposed to make an equitable division of the marital estate. In this case, there's debt, and the debt flows completely from a property that was owned by you alone, why, and therefore I assume that the income that tax liability was on flowed to you. In other words, you got the benefit of the sale. Why is it in those circumstances the judge, regardless of the joint filing status, couldn't equitably decide to allocate the debt entirely to you?
Two responses. First is that, as I stated earlier, throughout our marriage, we filed marriage filing jointly. So any gain or loss was on that joint return and was a responsibility of both parties. With regard to, what was your second question? I'm sorry, second part.
Regardless of the joint filing, why couldn't the judge equitably allocate the debt to you alone?
As both parties had testified, their testimony was that all of our monies went into the enterprise of the family, went into one account. So if there were profits, and there were, and I think both parties testified to that, they went into the same account and were for the benefit of the family. They did not.
Was there evidence of that, direct evidence of that this money went into a joint account?
Just the testimony of the parties at trial.
There was specific testimony that said from this sale went into a joint account.
Not this sale, as I said earlier.
Okay.
All monies that came into the family went into one account.
All right. You were very short on time, and I'm sorry to cut you off, but I do have one question for you, and that is the dissolution of the realty. Can you explain to me why this is important to you in a practical way?
Well, I've been a licensed real estate broker since, I think, in the 80s.
Right, but you could practice, you can conduct that business under another name?
I could, but that has been the name I've used throughout the time that I've been a real estate broker, and people know me by that designation. I've had numerous sales of my own to people that know me, or that I've met, that I sold a house to, and people that I've represented who know me by Realty Marketplace. Denying me that, I feel, is not allowing me to carry on the business in the way that I've been doing for over 20 years.
Okay, let me see if there are any other questions.
I do have one. With going back to the federal lien, the federal debt, am I correct that at some point during trial, you made a representation to the judge that debt would be satisfied or would no longer exist, I think in 2019, is that correct?
Yes, it is. And last year, the statute of limitation expired, and the total debt it's just under 400,000 was released.
So that debt no longer exists?
That's correct. But the payments that I made towards that debt from 2012 to 2018 totals over $50,000 that I alone paid towards that debt.
I understand.
Okay.
If I may ask one final question, I know your time is over. With respect to the realty company, did the judge, I did not see any explanation in the rationale for why the judge ordered the dissolution of the realty entity. Am I missing that, or did she not provide an explanation?
I really didn't see an explanation for it, other than the appellee asked for it. For what reason, I don't know, because the appellee cannot operate or own a real estate business by law. Massachusetts General Law, Chapter 112, Section 87 RR states that only a broker can conduct and operate a real estate business. So I'm not sure either why that was even brought up. And I don't recall anything specifically that the judge gave a reason as to why she made that determination.
Thank you.
All right, thank you very much. Attorney Bertrand.
Thank you, Anna. Donald Bertrand for Lynn Cheek. So I'm going to start by just picking up a couple of points that were just made in the last few minutes. Mr. Cheek just stated that he paid the IRS some $700 a month or whatever it was from 2012 to 2018. I would submit he did that with my client's money. That is, he was receiving every penny of his pension without giving my client a dime during that entire time. He basically used a portion of his pension, which maybe should have been going to my client, to pay the IRS. So he had more than half the pension for himself, took about 40% of it, that maybe should have been going to my client, and paid the IRS. So his claim that he paid the IRS, I would state that he paid the IRS with my client's money because she was entitled to those funds. She didn't, go to court to get the money, but the fact is he didn't give her a penny during that time from his pension. He kept it for himself. He used it for himself, and he paid the IRS monies that he incurred. Because in fact, going back to 2000, from 96 to 2006, when he and his partner, Mr. Graham, started out buying a property for $40,000 and then sold it in 2006 for $525,000. That's the Magnolia Square property. Again, my client had no involvement in that. We don't know where the mortgage money went. Mr. Cheek pumped the mortgage debt up to close to $500,000 from $40,000. We don't know where it went. He says, yeah, it went into a joint account. We don't know. There wasn't a scrap of documentary evidence that all that mortgage money either went into 14 Magnolia Square or went to the Cheeks. There's nothing except his say so that's how I did things. And when the reason he got stuck with the IRS assessment was because he didn't file a return for 2006. He never filed an amended return. He says he didn't have the documentation to show his investment in 14 Magnolia Square. That isn't on Mrs. Cheek, it's on him. And as Justice Neyman just pointed out, there is no more debt. So he's now going back in time and saying, well, she owes me the money I paid the IRS from 2012 to 2018. My point, he used her money to pay the IRS. That's my point. As far as not the taxes, the issue of his
dissolution of the realty entity.
Realty entity, right? The judge made a finding that he didn't testify that he was in the real estate business at that point. He said he was doing Uber and Lyft, and he was looking forward to retiring at full retirement age. Well, he's now 67, and excuse me, next month he's 67. He was 66 a year ago in November of 2019. So the judge took him at his word. He's going to retire. He wasn't doing real estate the last couple of years, and he had no intention of doing real estate in the future. So why does he want to keep Realty Marketplace going? I suppose because maybe he wasn't so retired. Maybe he was doing some realty work in the last few years we don't know about. I'm not going to make that accusation.
But how does that dissolution occur as part of an equitable distribution of the marital estate? In other words, is that really necessary as part of, is that really part of the assets of the estate that need to be resolved in this way?
Your Honor, from my standpoint, because I'm not my clients, I can say that I don't see that it's that important at this stage that he either keep the realty business or he doesn't. She wanted to be finished with her association with Mr. Cheek. So if there's a way for him to.
But there were ways. I mean, part of the order, said they have to close down the bank accounts. They have to do. I understand all of those things to remove remove any potential liability that she might have flowing from that or involvement. I get that. And I suppose I could understand why dissolution of an entity might be required if she were a stakeholder in some form, shareholder, whatever, but it doesn't look like that, right?
Something, Judge, it's been a while since I looked at the Secretary of State's document, so I don't know what if she's a stakeholder there or not. I can't say that. But I suppose there should be a means other than him dissolving that to get her out of there. And I think that should satisfy the order, the judgment of divorce. That we don't. I'm not sitting here saying that we have to. My client will tell you I want that dissolved, but I'm saying as her advocate, I don't think that's, as you said, necessary to
to protect her interests.
Right. So I agree with you.
Is that something that I don't know what change of circumstances would exist, but is that something that could be subject to a motion for modification?
Well, it's something
not that I'm encouraging further litigation.
No, that we don't need that, Judge. Your Honor, what we need to do here is maybe if the appellate panel gives an indication that would be something, a means of settling that that particular facet of the judgment, I'm going to encourage my client to follow that path, and without going back to court to do that.
Do you want to address the retirement allowance?
You want to? I went over my brief, and I think I handled all aspects of that argument in the brief. Again to point out that there's just no comparing a civil servant who gets a disability retirement award vis-a-vis someone who goes to the Industrial Accident Board who's lost an arm, as it was in D'Alessio, that kind of thing. Mr. Cheek makes much of these medical records that he produces, of course, after the trial, and wants this court, the appellate court, to now consider. Well, you know, he could have done that at trial, but I would submit that even if he did at trial, it wouldn't change anything. The fact is, what the medical panel found was that he couldn't do the job as a firefighter for the city of Boston. He was already in the real estate business. He didn't miss a beat in that regard. He got a wonderful lifetime pension on the disability, and he went right on doing his real estate work. And as we see, you know, from 96 to 2006, he's involved with Magnolia Square and other properties. He's buying, he's selling, he's collecting rents. He's doing all kinds of things. So he's not like he's sitting home in a wheelchair and he can't do anything. He's working, you know, in a new career. So where do we say that this compares somehow to? And he says he had some pain and suffering. Well, he finally had some back surgery in 2017, but it kept him off the golf course for a few months, and then he went back. He had played 7 rounds of golf in 2018 after the surgery. So this was just from April to August. So it wasn't like he's in terrible pain and he can't get out of bed in the morning. So I don't know how the judge would do that anyway, but the fact is it just is completely an opposite to D'Alessio in workman's compensation, where they break out pain and suffering, where they break out lost wages, where they break out your future lost wages. This is just, you know, he's very, very, anyone who works in that scenario, whether you're a police officer, firefighter, or whatever, you go on disability, and many, many times you can do anything but your job. I mean, granted, you can't do your job. He can't, you know, go up on a ladder and pull someone out of a burning building, but he can do lots of other things. And the city of Boston is taking care of him. He's getting 72% of his pay. He's getting medical benefits, which continue to today. And this is going to go on. You know, it was December of 19 before my client got a penny from the city of Boston. So from the time they separated in June of 07 to December of 19, 12 and a half years, Mr. Cheek didn't give my client a penny. It was 5 weeks before his 66th birthday when my client finally gets a dime from the city of Boston. And his full retirement age is 66. So I don't buy, you know, I don't know how anyone can buy his argument about pain and suffering and somehow carving up his pension and excluding my client from the one asset that they really have left. I mean, he got some money from his father's estate, which the judge gave him that. My client had $30,000 in debt, some of it from attorney's fees when this case went to trial, and she's stuck with that, and she's stuck with the attorney's fees. I assume from this hearing, I put in my motion for attorney's fees for the panel. I've always thought it's kind of a waste of time, quite frankly, to ask for attorney's fees at this level. But in this case, there's nothing new here. He's just dragging it out. He hasn't paid the alimony order. He hasn't paid attorney's fees since the date of this judgment. The judge gave him more time, 90 days to pay the attorney's fees. He didn't do that yet. She asked him to pay $75 a week from December when the pension started through August. He didn't pay a penny of that. So he owes my client $4,000 over the last, when he should have paid that over the past year or so. Just bad faith. It's bad faith, Judge.
I think we understand your argument. Let me see if there are any questions. I don't see any. Thank you both. It's an interesting case. We appreciate both of your arguments, which have been helpful to us, and the case is submitted.
Thank you, Anna.